Everyone, good morning, everyone. Hope you all are there to learn. First of all, you all are very much experienced and you might have already handled a lot of cases wherein you have already prepared the information memorandum, the RFRP, and all of these stuff which we will be discussing today. But this session is basically to guide you more on the legal provisions so that we do not miss out anything while drafting. And also we will discuss the impact, what happens if we miss out any of the important things, how it impacts the resolution plan, and what are the related case laws, which will give us a very good knowledge that what and how we should incorporate the things well in advance, and how to actually meet the challenges which we face in the daily course of our assignments, because most of the time the information is not with us. So it's not that we are lacking in our knowledge base or something, but it is just that the time frame is so constrained that we have to function within that time limit. And within that time limit, it might happen that there are various challenges in preparing that information memorandum in a very exhaustive manner as it is required. So how we can handle all these situations, what can be the best practices which can be taken up, and we can all share our experiences meanwhile. And obviously we will try to see how artificial intelligence can be used in this era for drafting purposes, because we might miss out something, but if we use the technology, we will be able to cope up with all the challenges for sure. So are you all ready to start with the presentation? So just let me know if you all are ready, because it's a very close, compact group of 32 people. So it shall be good enough if we interact with each other rather than having it a one-way conversation. So I have divided my presentation into three parts, wherein firstly we will discuss the information memorandum, the legal aspects, and the ways how it can be prepared, or what are the challenges, how we can mitigate those challenges. Secondly, we will be discussing about the EOI, and then lastly, we will be discussing about the RFRP. So all these will go simultaneously, and we will also have some cases or some exercises where you all have to tell me what are the mistakes, how we can correct that, or what will be the possible outcome if these are taken up as it is. So all the scenarios we will be discussing one by one. So I will start with the information memorandum, and I hope you all are ready to go ahead. It's a 3 hour session. What we will try to do is we will continue with one or two topic, and then we will take a short break, and then we will continue with the rest of it. Okay, so I'll start my presentation. Just give me a second. I'll share my screen. I hope my screen is visible now.
Yes, it is.
Okay, thank you so much for telling me, sir. See, rather than directly going to drafting part, let us first discuss what are the challenges in the preparation of information memorandum. Even the legal aspects you all understand. We will quickly brush through that, but we all understand that there are challenges in preparation of the information memorandum. Like there is some information which is not available, or the information which is available is outdated. There are some data gaps, there is some confusion, there is non-cooperation from the management. So how to deal with all that, and at the same time prepare the document which is legally fulfilling all the requirements. So that is something which we need to understand, and hopefully this session will give you some insights for that as well. So let us first understand quickly what information memorandum is all about. So it is a document containing all the relevant information about the corporate data prepared under section 29(1) of the IBC 2016. So it is the foundation document which is there to aid or to help the resolution applicant in preparing the resolution plan. So basically, it is the responsibility of the resolution professional to draft information memorandum in such a fashion that it attracts various prospective resolution applicants, and therefore we can finally resolve the corporate debtor. So it is all there in the drafting, how you portray something. So that is something which we must understand. So there are various legal provisions which tell you that how mandatory it is, and how effective it will be if you prepare it in a legal manner. So section 25(2)(g), it clearly defines that it is the duty of RP to prepare information memorandum. So if there is any loophole in the information memorandum, or if you could not enter the proper information there, so you will be, as an insolvency professional, as a resolution professional, you will be held guilty for that, and maybe legal consequences can be taken upon you. So you are breaching the code of conduct in a way if you are not preparing it in the way it has to be. Next is section 29(1). It tells us that RP shall prepare an information memorandum in the prescribed form and share with the COC and resolution applicant. So these first two sections, if you clearly see here, it lays down the duty or the responsibility on the resolution professional to prepare the information memorandum exhaustively as per the requirement of the law, whichever or whatever is given as per the law. We have to mandate that, because this is also one of our code of conduct, that we have to abide by all the legal regulations. Otherwise, some it will be considered as a misconduct and disciplinary action can be taken against us. Next is regulation 36. It tells us about the contents, format, timeline, confidentiality norms, etc. The deadline, which is mentioned in regulation 36(1), it tells us that submission of information memorandum to COC should be in the electronic form to each member of the committee within 95 days of the commencement. So P plus 95 is the final criteria within which this information memorandum has to be submitted, right? So finally, we have to understand how this all things can be taken up together. So firstly, let us have an idea what happened when there was some mistake or there was some error in the information memorandum, and how it impacted the overall resolution plan, or whether any action was taken on the resolution professional also. So this is the first case in front of all of you. It's ICICI Bank versus Gopal Sami Ganesh Babu. So the facts of the case are like CIRP had commenced and information memorandum was already circulated. A claim from a financial creditor was received after the COC had evaluated prospective resolution applicants. The RP admitted the claim and tried to modify the IM and reconstitute the COC. So what is the issue involved exactly here? The issue is whether the RP can admit claims and alter the information memorandum or COC structure after the information memorandum has been already shared and the resolution process is underway. So whether can it be done or not? So let's see what was the final observations and the conclusion in this particular case. Here, the NCLAT noted that such post facto changes created uncertainty. Late admission of claims after IM circulation undermines the process and disturbs the commercial decisions made by the COC. So the final judgment in this particular case was, just a second, NCLAT held that post information memorandum alterations should be avoided unless extremely necessary, and here they ordered that the existing process continue with the original COC structure. So here the NCLAT finally set aside the proceedings where the IM was not properly prepared or shared, reiterating that it is the responsibility or the duty of RP to ensure that the IM is comprehensive, accurate, and timely. So you cannot keep on making changes in the information memorandum if it has already been circulated. So that is something we must understand, though there might be the cases that we issue the different versions of it. But at the same time, it has been held in this particular case that post IM alteration should be avoided. And if it is extremely necessary, that can be done. Next case is in it is the particular case with respect to SR Steel India Limited. It's a Supreme Court decision. Here, the facts of the case are here the concerns were raised regarding unequal sharing of the information memorandum and data with the resolution applicant. So, different people were given different data sets. So, unequal sharing of information memorandum was there. So, that was the concern raised. Some resolution applicants claimed that they were not given fair access to the documents affecting the bidding process. So here the issue involved is whether non-uniform sharing of IM or the data violates fair process under the IBC. Of course, it should. So the observations are Supreme Court emphasized that all the resolution applicants must be given equal access to the information and opportunity to bid. So this is also something we must understand, that we cannot give partial information, or we cannot give unequal information to others. So equal distribution of the information should be there, and that should be our duty to abide by. Next, so the final judgment in this particular case was the court upheld the principle of level playing field and reinforced RP's duty to share information memorandum uniformly. The Supreme Court upheld the primacy of the COC but mandated that the resolution plans must not discriminate between the similarly situated creditors, and that the process, including IM preparation, must be robust, transparent, and compliant with the law. See, in this session, we will be discussing the drafting part, as well as how this this final version of information memorandum should be delivered or finally catered to people. Because sometimes it happens that we have prepared it in correct manner, but at the time of sharing it with people, there might be some complexities. So that is why these various cases are discussed, which are pertaining to this particular topic itself, so that we understand that right from the beginning of the preparation or the drafting till the final dissemination of the information, what are the checkpoints which we must understand, right? Next is the case of Binani Cement Limited. Here the facts of the case were, here the resolution applicant alleged that it was not provided adequate data from the information memorandum and the data room, while other applicants were favored. So it might happen that one of the resolution applicant may come up with such kind of allegation that he was not given proper access to the data room. So that is again very important. It is also our duty to see that everyone gets proper access to the data room as well. So here the issue involved is whether the RP can discriminate between the applicants in IM sharing and the data access. Observations were, the tribunal stated that the insolvency process must be transparent and non-discriminatory. What is the final judgment? Here they set aside the discriminatory practices and reiterated that IM must be shared equally and fairly with all qualified resolution applicants. The Supreme Court upheld this approach, reinforcing the need for the fairness and transparency in the CIRP. All right, so there's one more case to be discussed regarding Reliance Infratel Limited. It's a Delhi NCLT case. The facts of this case are certain significant contingent liabilities were not disclosed in the information memorandum, because it might happen that we ourselves are not aware of the contingent liabilities, but they were significant enough to be disclosed in the information memorandum, but because they could, impact in the drafting of the resolution plan also. So here the COC members later raised objections claiming incomplete information. So the issue involved here is, can omission of contingent liabilities from information memorandum be considered as suppression of material facts? Can it be taken that seriously? Observations. Tribunal found that RPs must err on the side of full disclosure even if the liabilities are disputed or uncertain. So it is the duty of the RPs that they have to disclose uh, everything and in entirety, basically. So even if it is a disputed case or uncertain case, everything has to be disclosed with proper remarks that maybe full detail is not available, but still, as on date, this is the current scenario, this is the current position. So the final judgment here is RP was directed to update and recirculate the IM with all the relevant information, ensuring all relevant information was included and shared with the COC and resolution applicants, reinforcing the RP's central role in ensuring transparency and compliance. So every time it is, from all these cases, we can figure out that it is the duty of the RP to prepare this information memorandum in such a fashion that nothing should be left out, everything should be disclosed, and it should be properly disseminated as well to all the people. Next, in the case of Jayanta Banerjee versus Shashi Agarwal, liquidator of Incab Industries Limited, it's an NCLAT decision. Here, the facts of the case are the entire CIRP was conducted without preparation of an information memorandum or the valuation of the corporate debtor. So, you can very well understand the seriousness of this case. The COC was constituted based on unverified claim, and the decision to liquidate was taken without proper process, including the absence of Form G publication for inviting expression of interest. Here, the issue involved was whether the failure to prepare an information memorandum and follow the due process invalidates the constitution of the COC and subsequent liquidation order. The observations were the ANCLAT found that the information memorandum is a critical document for CIRP. So this has to be prepared, enabling proper valuation and inviting the resolution applicants. The absence of an information memorandum and failure to verify claims before constituting the COC tainted the entire process. It emphasized that all CIRP regulations are interlinked and must be strictly followed. Because as we all understand, the ultimate object of IBC is to resolve the entity and not to take up the corporate debtor directly for the liquidation process. So everything must be done in order to consider that resolution process. So all these are very, very important aspects. So what was the final judgment in this particular case? The NCLET set aside the liquidation order, holding that the constitution of COC and subsequent decisions were invalid due to the non-preparation of the information memorandum and non-compliances with the CIRP regulations. So first you have to abide by all the CIRP regulations, wherein it is clearly mentioned that you have to issue information memorandum and everything with respect to the CIRP. And then if it does not materialize, then finally, or if it does not, the resolution process does not properly concludes, then you can go for this liquidation. So whether it is a misconduct, so in this particular case, we will here understand whether anything which is, shortly done or, erroneously, if something is missed out, something like that. So if whether that will amount to or whether that will amount to a misconduct on the part of resolution applicant, resolution professional, sorry. An RP could not prepare the information memorandum because the corporate debtors' premises were sealed by the Chennai Metropolitan Development Authority. In short, we will call it CMDA here. The disciplinary committee initiated action against the RP for non-compliance. See, what happened was there was the premises where the valuation for which should have been included in IM could not be done because it was sealed by CMDA authority, and they denied to allow any kind of valuation to be done. So the information memorandum did not contain the valuation for that particular premises. So here the disciplinary committee initiated action against the RP for non-compliance. Here the issue involved was whether RP can be penalized for failing to prepare an IM due to third-party actions. So even if it was, not his fault completely, but due to third-party action, here CMBA is the third party, they did not allow them to evaluate that particular premise. Therefore, the IM could not be prepared. So ultimately, it what will happen in this particular case? So that is what we are understanding. Can we shrug our responsibility, saying that we could not do something because the other party denied us from the excess of that particular property? Can we say that way? So the observations here are: the DC acknowledged the RP's efforts to access the records, including obtaining court orders, but CMDA non-cooperation prevented compliances. So here you can very well see that you have to maintain a record, proper documentation you have to do with all your efforts which you have done, because that will only safeguard you against the disciplinary action. If you plainly say that since they denied, I did not try at all, so that will clearly lay down, uh, uh, it will tantamount to misconduct on your part. But if you can prove that yes, I tried my level best to access those, and if you have the proper communication with you, and what all efforts you made to have those the valuation of that premises, and you tried your level best to do each and everything, but you could not succeed, so that is something you have to document and you have to keep with yourself, so whenever asked you can produce the same. So here it was mentioned by here the DC acknowledged that RPs had made proper efforts to access the records, including obtaining court orders, but CMDA non-cooperation prevented the compliance. The NCLT and NCLAT had already exonerated the RP in earlier proceedings. So the final judgment was the DC dropped the charges, recognizing that external factors which were not in RP's control, and here also RP was not negligent. So this failure was not on his part. It was not taken as per misconduct. Next case is with respect to Vijay Kumar Jain versus Standard Chartered Bank and others. What are the facts of the case? The appellant is here the member of the suspended board of directors. He sought directions for the RP to provide all the relevant documents, including the resolution plans and information memorandum, during the CIRP of the corporate debtor. Here the issue involved is whether members of the suspended board of directors are entitled to receive the information memorandum and resolution plans during the CIRP. So again, it's not just the drafting part, but also whom should it be delivered to. That is also something we must understand, whether we are supposed to deliver it to the members of the suspended board of directors also, whether it is our duty to give it to them. Is that so? So that is the case involved here. What are the observations? The Supreme Court observed that under Section 24(3) of the IBC, participants, that is including suspended directors, are entitled to the notice of the COC meeting. That is okay. And to receive the copies of the documents relevant to the matters to be discussed. However, the right to receive the IM, that is the information memorandum, is not absolute and is subject to confidentiality requirements. We all understand that information memorandum is given only after taking the undertaking of confidentiality. The court clarified that while directors have a right to participate and access certain documents, this does not automatically extend to all the confidential documents like the information memorandum unless specifically relevant to the agenda. So what was the final judgment here? The Supreme Court partly allowed the appeal, holding that suspended directors have the right to receive the documents placed before the COC for the decision making, but not a blanket right to the information memorandum. The RPs must balance transparency with the confidentiality. So normally it is not the duty of RP to give it to them, but if they really insist, then a proper undertaking of confidentiality should be taken, and then you can deliver it to them. Next, in case of Vinay Kumar Singhal, RP for PG Advertising Private Limited versus Mahesh Bajaj. This is again an NCLAT case. Here the facts are: the suspended board of directors sought access to the information memorandum. So it's a similar kind of case. The RP refused, stating that IM is confidential and only for the COC members and resolution applicants. So here the issue involved is again whether the RP is obligated to share the IM with the suspended board of directors. I think you already understand the scenario here. So this has been again highlighted. There are two different cases we are discussing here, because sometimes the board of directors or the suspended board of directors pressurize the resolution professional that you are not abiding your duty to deliver this information memorandum to us. So this has been made very, very clear that there is a difference between members and participants. And again, to whom this document has to be shared with. So here, let us understand what were the observations. The NCLAT Mumbai bench and the NCLT Mumbai bench and the NCLAT distinguished between members and the participants as defined in the CIRP regulations. It noted that the code and regulations only provide for sharing information memoranda with the COC members and resolution applicants after taking confidentiality undertaking. So this is very, very important. Even if you are sharing it with the members of COC and the resolution applicants, from both of these parties, you have to take confidentiality undertaking. However, not with the participants such as the suspended board of directors. So there's a distinction between members and participants. Though the suspended board of directors can participate in the meetings and all, but they are not supposed to get this information memorandum, mandatorily. The Supreme Court's decision in Vijay Kumar Jain, which we had just discussed in the earlier slide, was held to apply only to COC members and not to the participants. What was the final judgment here? The tribunal held there was no violation of the code or regulations in not furnishing the information memorandum to the suspended board. Here the IM is, so finally it was stated that the IM is to be shared only with the COC members and resolution applicant, maintaining its confidentiality. So this is something which we all must bear in our minds, with whom to share and with whom we should not compulsorily to share. So what are the common non-compliances in information memorandum and what could be the impact or what could be the risk? The first non-compliance could be omission of litigation or the contingent liability, which we have already seen in one of our cases, that if you miss to report out the contingent liability in the information memorandum, then what impact it could have? The plan may be challenged post approval also. So even if the resolution plan has been approved, then also later on also it can be challenged. Next, non-compliance could be with respect to the inclusion of outdated or inflated asset values. Sometimes it may happen that your valuation is of, it is of outdated scenario, or the valuation or the assets value which you have taken are inflated. So this will indirectly mislead COC and the resolution applicants, and it will invite disciplinary action on you. See here, you might ask that normally the valuation is done by a valuer. That is a separate entity, and that is a separate expert person with whom we hire for valuation purpose. But the ultimate responsibility lies on the resolution professional only. So if there is any, later on, if any discrepancies found in the valuation, the resolution professional will be held guilty. So you have to make sure that whatever valuation is done, whether it is within the scope defined and whether it meets out all the valuation standards, the valuation is done properly or not. You have to sit with the valuers and understand how they have computed. That is something which you must do. So it is not that you can shrug off your responsibility saying that it was done by some external person or some other expert. We are not liable for it. You cannot say that. You cannot shrug off your liability here. Next, non-compliance could be with respect to the missing material disclosures. For example, some of the important operating licenses, if they have expired and you have not included that part in your information memorandum, or there are some NOCs which are not taken or which are supposed to be taken to continue the business, but they are not being done. And if you're missing out those things, then obviously these are the material things which should be disclosed for the resolution prospective resolution applicant to understand the whole scenario of the going concern of the corporate debtor. So here the RAs may back out or revise the bids. They have this right to either back out or revise the bids if later on it appears that these material disclosures were missing. Next, non-compliances with respect to the delayed IM preparation. So even whatever you are preparing, you have to prepare it within the time frame. So even if you delay the information memorandum preparation for the sake of gathering all the information and everything, no, that will not be allowed. You have to do everything within the time frame. That is also very, very important. So again, if you are delaying the preparation, then it will be a kind of breach of statutory timeline, and it may delay the CIRP process altogether. Next is improper sharing of information memorandum. Then obviously we have already discussed that it will tantamount to breach of confidentiality, and it will create a kind of a legal liability for the insolvency professional. Let us now understand what are the roles and responsibilities of IP in order to prepare this information memorandum. So first of all, he has to collect the data. Now here the question arises from where we should try and collect the data. Sometimes the corporate debtor or the management is not cooperating. So how to get the information from them, or how to get information from any of the third parties, how to get that. So here the first responsibility which is catered on us is to collect the data. So collect all the financial, legal, and operational data from the corporate debtors' books, statutory filings, management, auditors, and forensic reports. So whatever data you already have, you can access to that. Besides that, from the MCA portal also, you can get some information because regular filings might have been done by them. Then also nowadays, it has been made a duty on the part of the creditors to share the information which they already have with respect to the corporate debtor, because uh, when they have given loan to the corporate debtor, they might be seeking some regular information from them. For example, their stock confirmation reports or their financial statements. So they might be having some data which could be of use. Whatever period it is pertaining to, the latest data with whatever you can have it from those creditors, you should try and gather that as well. And from various statutory authorities also, you can seek guidance and you can seek their help for obtaining the data. Next is regarding validation and accuracy. So it's not just to collect the data. Now it is the responsibility of the IP to validate the data and to check the accuracy. So cross-check the information for completeness and correctness. This includes reconciliation of claims with the books, verification of litigation from legal databases, and due diligence with the statutory authorities. This is how he should proceed. There was some case wherein, the previous auditor did not conducted the audit in the good way, or maybe there were some qualifications, but he did not report that out. Later on, it came to the knowledge of the RP, but he still missed that, saying that when the previous auditor has given this kind of data, I have to take it as it is, even though there were some discrepancies. So since the data was not complete, it was not correct, and it was not reconciling, again, you cannot say that you are relying on other person for the information. It is your duty to again validate and check the accuracy of the complete data set, whatever you are presenting in the information memorandum. Next, regarding the confidentiality compliance, ensure that the IM is shared only with those who submit a confidentiality undertaking as mandated by the regulation 36.4. The RP must maintain logs of who accessed information memorandum and ensure no leakage. I wonder how many of you prepared this kind of log, that to whom you have shared information memorandum, and within that the name of the person, date on which you have shared, and again you have to take mandatorily the signature of that person, and maybe you can have a column whether proper undertaking was given by them or not. So if the undertaking was not given by them, then obviously it is your fault. You have not taken that. So everything has to be documented. You have to be on a safer platform saying that I have delivered the information memorandum to these people and after taking the relevant information, this undertaking of confidentiality. And that is how you can say that there was no leakage of information to any outsider. Next is engagement with the stakeholder. How you can say that, I mean, whatever you are preparing, again and again, you have to interact with the stakeholders. So don't consider that you are working in silos. Even if the management is not cooperating, then there are other stakeholders also from whom you can get the informations, who can help you out in preparing the information memorandum. They can tell you that where all the assets could be and how that you can access to those informations. So lies with the COC for the inputs on evaluation metrics, market feedback, and required disclosure. The RP may also interact with the prospective resolution applicant to clarify. Uh, uh, the RP may also interact with the prospective resolution applicants to clarify the data without breaching the confidentiality. So that is something which can be done. Moving further, again there are some more roles and responsibility, the valuer coordination, because you cannot say just that uh, we have blindly taken the valuation done by some expert. So again it is our duty to check the valuation, the method which they have adopted, and we are responsible for the final valuation, whether they have taken all the assets in consideration or not. So that is what we have to do. So assist in the appointment of two registered valuers to determine the fair and liquidation value. Share required information memorandum data with the valuers as per the regulation 35(2). See, it is very, very important that we provide them sufficient information. If we are not providing them sufficient data, how will they value it to the it to the finality? So ultimately, they will also say that since we could not get enough data, we could not value it properly. So ultimately, the ball will again fall in your court. So in order to safeguard yourself, you have to provide them sufficient data and you have to regularly interact with them. Maybe there are cases that you might come to know that there is some more asset lying somewhere else, may not be in the premises of the corporate debtor in some other city, in some other country also. It might happen that during the interaction with other stakeholders, you come to know that this kind of things are also happening. So that information is also to be given to the valuer. Then you have to maintain the data room. Host a virtual or physical data room with access logs and facilitate document sharing for the resolution applicants to conduct due diligence. Then again, you have to uphold your integrity. The RPs must not influence the COC or RAs by omitting material facts. Their independence and objectivity in the information memorandum process is central to the credible CIRP. Finally, the disclosures and the reporting part. Is my screen visible?
Yes, it is visible.
Yeah. So something has happened at my side. Just a second. I have to stop share and then share again. Just a second. Am I audible now? There was some issue at my end, so sorry for that.
Yes, ma'am, you are
Yes, yes.
audible.
Okay, thank you so much. Thank you so much. Sometimes I say it that way. Some of you might be actually insisting for the break, maybe inside their heart, and it has been conveyed in this way. But let it be. We will just resume whatever we were doing. Just a second. We were discussing the roles and responsibilities of insolvency professional. Just let me know if my screen is visible. I'm just making it full screen. So these were the points which we had discussed regarding the disclosure.
Yes, visible.
Yeah, yes, sir. Thank you so much, sir. So regarding the disclosures and reporting, the RP must report the status of IM preparation and sharing to whom all he has shared to the adjudicating authority and the IBBI also, especially in cases where delay is unavoidable. So just to be on a safeguard, and also it is your duty to timely, report out through these CIRP forms. So that way, again, it is your responsibility. So wherever there is a delay, if you are foreseeing that there might be some delay, so you have to report that out specifically to both these authorities, adjudicating authority and IBBI as well. So that it does not make an impact on your conduct at any point of time. Next is, what are the consequences of non-compliance? So what if a resolution professional is, if he could not comply with any of these scenarios? So failure to prepare IM. So failure to prepare IM should be constructed in a way that he has not prepared it as per the legal provisions. Something or the other is missing, or maybe if he has prepared, he has not delivered it to the proper persons, and the repercussions like that. So failure to prepare IM, whether complete, incomplete, or whatever, is equal to breach of section 25 2G and section 2(1), subsection 1. So again, if it shows that it is breach on your part, obviously it will tend amount to a misconduct, and legal actions can be taken, or disciplinary action can be taken on the resolution applicant. Finally, as we are saying that it is a breach of conduct, so in then breach of duties, or it will tend amount to breach, then it attracts the disciplinary action from IBBI. It may even lead to liquidation if IM is delayed and no resolution plan is filed. So let us understand it quickly through this table. As per section 2082A, if there is a violation with respect to failure to perform duties diligently, then disciplinary action can be taken by IBBI on the resolution applicant. With respect to section 71, deliberate omission or misconduct, if that is something which is found, then in that case imprisonment up to 5 years and a fine up to 1 crore can be levied on that person. Next, section 65 or 66, under those sections, what is the provision? If there is a fraudulent or wrongful conduct during CIRP, then there is a personal liability or criminal prosecution. Then next, with respect to IBBI Inspection and Investigation Regulation 2017, if there is any delay or inaccurate information memorandum, then the consequence could be suspension or cancellation of the registration. Fine can be levied on the resolution professional. Fine can be imposed on him. Then finally, what are the challenges in preparing the information memorandum? I hope you all are very well aware of these challenges. First of all, we have limited access to data, how to overcome that. The next is outdated or incomplete records are there. There is non-cooperation of these stakeholders. Uh, how to determine the material information. Sometimes when we are not having enough information, how to determine whether it is material or immaterial, or how to take that out. The next is sometimes the case is so complicated. The corporate debtor has, several subsidiaries or maybe group companies are there. So complexity of the corporate structure may also lead to, challenge in preparation of information memorandum. And obviously there are time constraints within the limited frame of time. You have to do everything. So, what are the challenges and how we can mitigate them? That is very, very important for all of us to understand. Firstly, when we say that there is a non cooperation from the management directors, what you can do is immediately file an application under section 19(2) of the IBC, sorry, before NCLT for direction. So if you understand it at the very inception itself that there will not be any cooperation from the management or the directors, then instantly you have to file this application. Don't wait for, don't delay. That is very, very important. You have to file it immediately. Next, use statutory filings, tax records, GST, ITR, ROC data as independent sources. So this is something which we have discussed in earlier slides also, that even if the management is not cooperating, you have other sources from where you can get the information. So utilize that. You can access to the GST returns, you can access the income tax portal, you can obtain those ITRs, you can have the MCA records, I mean the ROC filings which have already been done, and various other statutory filings. And from the creditors also, you can have those data for yourself so that you can start up preparing the information memorandum. Next is consider forensic support to reconstruct books from third party data, that is banks and vendors. So if you get some or the other information from these third parties, it might not be complete information. So you need to seek help from the forensic auditors or the forensic data analysts. So that way you have to proceed. So you should see, it is allowed for every one of us, for all the resolution applicants, that we must try and complete the things in time, well within the time. So for that reason, we can seek help from various experts. So don't wait for the last moment. Just try to, appoint as many experts as you can. Keep yourself free. Don't engage in everything yourself. You have lots of hands to support you. So forensic experts can be there to support you from the very beginning itself. When you already know that you don't have much data, then how to reconstruct all that is a big task and a big challenging task that also requires time. So from the day one itself, maybe you can plan for appointment of these forensic auditors. Next is, in case of incomplete or unreliable financial records, you can appoint forensic accountants to reconcile the bank statements and statutory returns, as we have already discussed. Use the audited reports of the subsidiaries and consolidated accounts wherever available. Next is engage statutory auditors to assist in the reconstruction. Obviously, you can seek help from the statutory auditors as well. Next is with respect to disputed claims and valuation uncertainty. You need to establish a cutoff date and disclose disputed claims separately in the information memorandum. Highlight the basis for provisional admission in the notes. For the valuation purpose, you have to engage experienced valuers who can factor the uncertainties. See, it is very, very important to appoint different valuers for different class of assets. It is already there in the code that for different class of assets, you have to appoint different valuers. You cannot ask the same valuer to value each and every class of assets. So again, you are distributing your work to various agencies so that your work will be accomplished in time. That is something which we need to take care of. Next is regarding timeliness and regarding the timelines and the procedural delays. Create a CIRP calendar at the outset itself and communicate it to the COC and the stakeholders. So as we already have the timeline with us with respect to that, put the dates, whatever dates will be relevant for each and every deliverable, and that has to be communicated to the COC and all other stakeholders also. So it is not just our responsibility to fulfill the timeline, but they should also be aware that we have to fulfill or we have to complete all the things within the time frame. So that is something we have to communicate it to them as well. Next, parallelly, you have to track the activities, claim verification, data room setup, and valuer appointment. Next is prioritize the critical data for initial information memorandum, and then you can keep updating it with the annexures if necessary. Next is regarding the confidentiality risk. We have already discussed that. So, strict enforcement of regulation 36(4) should be done. You need to obtain board resolution and indemnity from the applicants. Next is you can use the secure VDRs with role-based access control and activity logs. See, whosoever is approaching these data rooms, you have to prepare a proper log that who visited at what time, and you should have the record with you that and the proper undertaking that they will not disclose this information to anyone else. So that is something which you need to maintain. Next is include legal review of all the data sharing protocols. Next is legal regulatory risk and liability. So in this particular case, you have to maintain robust documentation like working papers, corresponding logs, and the source data, so that you can justify that you have taken into account all the risk and the liability. So everything has to be documented just to safeguard yourself. Next is engage legal advisors to vet the disclosures and confidentiality undertaking. So if you are not very much sure that whatever I have disclosed, whether it is sufficient or not, you can again take help of the experts or the legal advisors to do the vetting for you. And if anything is left out, you can you can do further disclosures. And obviously, if you are giving it to someone or the other expert persons, then in that case also you have to obtain this confidentiality undertaking, again because you are disclosing the confidential data of the corporate data. The next is share the regular updates with IBBI if delays or disputes arises. So again, communication gap will create a problem. So every time whatever new thing has happened, or if you think there might be some kind of delay or dispute, then again you have to communicate it uh, with the proper authorities, and you have to maintain the proper record of it. Next is what could be the checkpoints. So what are which are very very essential for all of us to understand. So share this information memorandum only with the eligible resolution applicants, and you have to get this non-disclosure agreement signed with them. Next is IM should be prepared within 95 days from the ICD. The next is updated information memorandum should be issued after COC change or any new disclosures are there. The next is valuation disclaimer should be included or not. That is something which you should be very, very cautious of. The next is data limitations, whether they are disclosed transparently or not. That is all you need to understand. Now, one of the questions which there might be in your mind is, can information memorandum be accessed on public domain? Can anyone have a look at that? Or can anyone access that publicly? So normally the answer is no, because information memorandum is not a public document. It is shared only after taking a proper undertaking of confidentiality. So it is not a public document. It is shared only to some specific people. So it is a confidential document. It contains sensitive business data, trade secrets, customer suppliers list, litigation risk. So all these are very, very sensitive information. It may influence valuation, bidding strategy, or plan the manipulation. Then next, the disclosure here may violate. So if IM is disclosed to some other parties, then it may violate the non-disclosure agreements, competition laws, or privileges to other parties. So it is very important to understand that the information which is there in information memorandum should not be leaked otherwise. Otherwise, everything will fall on the resolution profession only, because he is supposed to maintain the confidentiality. Next, talking about section 29(2) of IBC, here it is mentioned that RP shall provide the information memorandum only to those persons who have submitted an expression of interest and have met the eligibility criteria under section 25(2)(h), then signed a confidentiality undertaking. So if these parameters are met or these conditions are fulfilled, only then RP is supposed to provide the information memorandum to these persons only after obtaining the undertaking. Then again, it is mentioned in IBBI Regulation 36A, Clause 10, that IM shall be shared only with the prospective resolution applicant who comply with Section 29A and sign a confidentiality undertaking. So it is very well understood that it is not a public document. It is shared with only specific people, and that too after obtaining the confidentiality undertaking, right? Next is who can legally access the information memorandum. So who can be the user of this? So COC members, they will automatically access it. Then prospective resolution applicant, only if they are eligible and if they are ready to sign this non-disclosure agreement. The next is IBBI NCLT. Obviously, they can have access for this information memorandum for inspection purpose, or in case of any litigation, they can have access to it. The next is liquidator. If in case CIRP fails, then in that case, liquidator will have access to the information memorandum, and he may request for the future sale process references as well. Next, what could be the action plan for IPs when records are unavailable or there is a case of non-cooperation? I think we have already discussed this, but still there are some, again, it is mentioned again and again because that is the biggest challenge which we face. So if there is anything like that, there is no support from the management, then again, you have to issue formal notice to the corporate debtor requesting records within 7 days. So, firstly, you have to issue notice to them. And if they are not doing anything within 7 days, then what you can do is you can finally file an application for non cooperation under section 19(2) and then you can request NCLT to further direct you how to proceed. Why it matters? Because it is mandatory for building cases of non-cooperation, because you must have some supporting saying that you tried and approached to the management, you tried and approached to suspended directors, but they are not cooperating. So verbal things will not work out. You have to have some written evidences therein. Chain mails you can show, or if you have issued this kind of notice, that you can show as an evidence to get this direction from NCLT under section 19(2). Next is you need to file written communication log, proper emails, courier proofs, if any, then that is what is required, because every time you are communicating with the suspended directors, it has to be on records. That means you have fulfilled your part, but they are not doing it from their side. So this will help in future compliances and audit purpose also. Next is conduct basic forensic scan of the available data from ERP, which is available, or maybe from the Gmail also, you may track out the details. From the banks also, you can get the informations. Nowadays, from social media also, you can get the data. From the website of the company or the corporate data, you can get the data. So all that analysis can be done. That is the raw data which you can have, and then again you can appoint a forensic expert for that particular reason, or the IT auditor, to further analyze the situation and present it in a better shape. So even partial access helps track fund flows and the gaps. So don't restrain yourself or don't restrict yourself, that you are not appointing experts to help you out. You are there to work within the time frame with the help and with the support of others. So you can even use the help of expert, as many experts as you want, but this has to be disclosed to the COC, and fees approvals should be taken in the COC meetings. That is for sure. Then next is you need to file application under section 19(2) for non-cooperation. This can be used as a legal recourse via NCLT. How you can take this up with the NCLT? So this 19(2) non-cooperation application can be filed. The provision is mentioned in IBC and NCLT rules. So this is the expected relief. Personal appearance will be demanded, or maybe directions can be given to hand over the records. So that is the best recourse which you can take. You can even ask for penalty and imprisonment if any fraudulently if they are actually concealing the things fraudulently, or there is some kind of misconduct on the part of the management. That is something can be done. So I'm moving further. Parallelly, you can approach to these third parties for the information. This we have checked already. Uh, Let us now see the a draft of the information memorandum, how it should be prepared. So I'm just stopping my presentation here. I will quickly take up the information memorandum contents as well as how to prepare that. So firstly, we must understand what are the legal requirements and then how to build upon it. We will check that out. Just a second. Let us first understand what are the various contents which are required. Yeah, I hope my screen is visible now. Okay, so these are the legal requirements. I think I can enlarge the size here. Yeah, so we already understand if we talk about the information memorandum, what all legal provisions we must adhere to. First is the regulation 16 of the CIRP regulations. Then section 29, we must understand it should also be there. And then IBPI circulars and various guidelines. So we have to adhere all that. Then what are the mandatory requirements with respect to the uh, uh, contents of the information memorandum? So first and foremost is with respect to the corporate debtor information. You have to provide the information regarding corporate debtor. What all information is required? First is you have to uh, mention the corporate identity, that is the SIN number, corporate identification number, and the registration details. That is on top, you have to mention that. The next is the registered and the corporate office addresses. Next is the nature of business and industry classification. Then corporate structure and group entities. Then list of directors and key managerial personals, and then date of incorporation and company history. So all this should be there in this first heading, which is known as corporate debtor information. Next is financial information. With respect to financial information, what all data you must have? The first and foremost is audited financial statements for last 3 years. Next is provisional financials till CIRP commencement date. So obviously, if you don't have the data, you need to appoint some experts for that, and you need to have all those financials ready so that you can incorporate that in the information memorandum. Next is with respect to details of assets, that is tangible and intangible, both the assets you have to mention there. The next is list of operational creditors with the proper amounts. Then next is list of financial creditors with their amounts. Then next is details of contingent liability. See, this is also mentioned as a content which you have to specify with the in the financial information part. So you cannot ignore this part. So details of contingent liability should also be disclosed. Then next is tax liabilities, if any. So with respect to income tax, GST, or any other statutory dues, if there are any, then you have to disclose it here itself. And next is the employee liabilities and dues. The third aspect would be the asset details. What all assets details are required to be disclosed. The first and foremost is the immovable properties along with their encumbrances. So if any immovable property is encumbered, then in that case, you have to specify the details with which loan it is, what is the time period, and what is the amount and everything. So this is very, very important, that not only the name of the immovable property, its amount, but also the encumbrance, if any, you have to mention. Next is movable assets and machinery, inventory details, book debts and receivables, investment and securities, intellectual property rights. So this is something which we might miss. So this is very important. How will you get to know about it? Sometimes it is highlighted on the website itself. Maybe they have taken some trademarks or they have taken some brand names. So that way you can check it out. So intellectual property rights are also to be mentioned, because at the time this can also be valued. You can assess the financial value for these intellectual properties at the time of when you are giving it to the prospective resolution applicant. You can figure out a proper valuation for these as well. Next is valuation reports, liquidation and fair value. Both the values should be highlighted in the valuation reports. Next is liabilities and the claims. So admitted claims. What are the admitted claims? For the financial and operational creditors, both, you have to mention it here. So in the first part, we saw that you have to mention here the list of financial creditors with their amounts, list of operational creditors with their amounts. That is the total entirety amount which is to be mentioned. But how much is actually accepted, that is to be separately mentioned here. So that will fall part in the liabilities. Next is claims under verification. So if there are any claims under verification at the time, even when you are preparing this IM, that is something which can be disclosed here. Next is rejected claims, if any, and their reasons of rejection also. So it is not just that you are ignoring it completely. You have to mention what all claims were rejected and why it was rejected. So reason is again very, very important. Next is secured versus unsecured and the breakup of that. So whatever loan is secured and the unsecured creditors part, whichever is there, you have to give a proper breakup of that. Next is workman dues and the priority payments, so that everything is there in the information memorandum itself. Nothing is left out. And at the time of making the waterfall mechanism, using that section 53 model, in that case, you have all the figures here with you. Next is government dues. That is also to be mentioned separately. Next is legal and regulatory part. Here you have to mention if there is any litigation going on, if there is any pending litigation, what is the matter, and what is the tentative amount of liability or anything which you can which you have the idea, you can mention it here. Next is regulatory approvals and licenses. So if you know that this is one of the headings for which you have to mention, then only you will look up to it. So sometimes it is the need for running any industry. You need to have proper licenses, proper regulatory approvals. So at least that has to be mentioned. And again, you have to see whether proper renewal is done for them or not. And if it anyhow it has been cancelled, that is something also you need to mention here. Then next is any material contracts or agreements, that should also be mentioned. Then next is security interest registered. Next is guarantee and letter of comfort details. So if the entity has provided any guarantee to someone, or that is something you should mention here. The next is compliance status with other laws. So if everything is being complied, that also you have to mention. If there are some cases where you think the compliance is not there, then you have to mention it separately in this part. The next is CIRP process details. So when did CIRP commenced? Then name and the contact of RP, IRP. You have to clearly mention that, so that they can really reach out to you in case of any queries. Next is committee of creditors composition. Next is timeline for submission of resolution plans. And lastly, it is mentioned that the eligibility criteria as per section 29A, because we just now read that only those persons who are eligible will be able to get this information memorandum. So ultimately, the criteria has to be mentioned, that you have to be the proper resolution applicant, or the prospective resolution applicant has to be eligible as per this section 29A. So what is the criteria? You have to simply mention it there. Then disclaimers also you can add, like as is where is basis disclosure. This is what the detail we have. No representation or warranty clause. Then verification responsibility on prospective bidders. They can check the premises. You can mention date, or you can mention the time lines when they can come and personally check for the verifications and all. Then confidentiality obligations, you can have that. So this is what are the contents which are required of you in order to have the proper information memorandum as per laws. So now let us also have a look at one of the sample information memorandum so that we understand how we have to prepare the information memorandum. So I'm just sharing that. Just a second. Just let me know when my sample information memorandum slides are visible. Is it visible now?
Yes.
Yes, visible.
Okay, okay, sir. So this is a sample data which is taken wherein this information memorandum is prepared in respect of Gilco Exports Limited. This is the corporate data here. So here it is on the main page itself, it is mentioned that pursuant to section 29 of the IBC, read with regulation 36 of the IBBI regulations, and it is prepared by whom? So the details of the IRP or the resolution professional, it is mentioned in the first page itself with his registration number, his complete address, email ID, and phone number. So this is mentioned in the first place itself. Moving to the, and see, on each and every page they have mentioned it strictly private and confidential. This is supposed to be mentioned. Why this is supposed to be mentioned every time? Because actually this data is very, very confidential, and you are when you are writing it on each and every page, you are making the other person realize that it is really private and confidential, and that is why they have to give that undertaking, and they are not supposed to share it with anyone else. So that is something which you should mention. Then this is the index which you can have here, index to the information memorandum. So part A, it says the IBC advantage, the abbreviations and the definitions, the disclaimers, if any, then if there is anything general which has to be mentioned, then what are the risk and the confidentiality clause. That all is mentioned in the first part. So that shall be common for anyone. Then this is more specific. Part B is very, very specific for any particular corporate debtor. What are the headings? Let us first understand that, and then we can see the rest of the things. First is the about the corporate debtor and the key selling propositions. First of all, because about the corporate data, you will have the entire, details, brief details, I would say, about the corporate data, directors, the business, the industry which it is involved into, and, the registration detail and all, and also the key selling propositions. Why you want the other person to have this, take this up as a good option. So you are actually trying to attract the resolution applicant. So key selling propositions should be highlighted that this is the strength of this corporate debtor, and this could be an opportunity for the other person. Next, events leading to initiation of the corporate insolvency resolution process. So this is again should be highlighted because the other person should understand why or what were the events which led to this CIRP situation for this particular entity. So what are the consequence? What are the what are the systematic or the events channel of events? What has happened, which have lead to these this kind of situation? The next is master data of the corporate debtor. Next is board of directors of the corporate debtor, the complete detail about them. Then next, if there are any charges created, so index of charges will be separately mentioned. Then status of the assets of the corporate debtor, then the current status of the corporate debtor. So all this has to be mentioned. Next part is with respect to the financial details of the corporate debtor. Herein we can simply see all those headings which we had earlier checked. Assets and liabilities as on the insolvency commencement date. See, this is very, very important. It is not just mentioned that you have to just detail out the assets and liabilities, but the date is very important. This is the updated information as on the insolvency commencement date. So till that date, what is the exact scenario, what is the exact financial data which you have, that is something which has to be presented in this information memorandum. Next is the details of the financial creditors, details of the operational creditors, then what are the government dues, any other dues, details of the related parties, material litigations in respect of the corporate debtor. So again, the litigations which are going on, what is the current status, that you have to mention here. So now we are checking the details. The first part, the IBC advantage. So they have mentioned it. It is a why you are opting for this IBC and why you are opting this CIRP process. So this could be something, taken for, this can be taken as a general thing for each and every uh, IM for any of the assignments which you have. And these are the abbreviations which you can have a list of all the abbreviations which are used in this IM. So a complete list of that. Then we have definitions also. So that the resolution applicant does not have to check from the other sources. He does not have to Google out the things. So everything is mentioned in the document itself. What do you mean by the company? What do you mean by the articles of association? What do you mean by the board here? So board here does not mean the board of directors, but it means Insolvency and Bankruptcy Board of India. If we say board of directors, then it means board of directors of the company. So clarity has to be there. So therefore, these definitions and all. So whatever definitions you want, you can have it. This is the standard thing which you can all use. So registered office, they have put the address that here the registered office of the entity is there. What do you mean by charge? What do you mean by claim? So all those words which will be frequently used in this document. What do you mean by default? What do you mean by financial institution? What do you mean by property, secured creditor, security interest, transfer, transaction? Then what do you mean by workman? Then who is the adjudicating authority? What do you mean by chapter? I mean, these are all the things which can be commonly used in any of the information memorandum as the initial pages. And here the disclaimer is there. This information memorandum pertaining to this particular entity has been prepared in terms of section 29 of the IBC 2016, read with regulation so and so by the interim resolution professional or the resolution professional. This IM has been prepared for the consumption of the Committee of Creditors of Gilco Exports Limited and the prospective resolution applicants, if any, for the purpose of ascertaining the financial position of the company and to assist them in preparing the resolution plan for Gilco Exports Limited. Reliance should not be placed on this document for any other purpose. So this disclaimer is there that this should only be taken up or it should only be looked for this purpose of resolution process only, for making your resolution plans, nothing else beyond that. The information provided in this IM is based on the information supplied by the management of Gilco Exports Limited and other public sources, and to that extent, no representation or warranty is given by the IRP or RP as to the accuracy, correctness, reliability, or completeness of the information contained in this information memorandum. So you have given your disclaimer also here. And to the extent permitted by law, IRP or RP accepts no liability and disclaim all responsibility for the consequences of anyone acting or refraining to act in reliance on the information contained in this report or for any decision based on it. This document, yes, sir.
Will this disclaimer actually help?
So it is advised that you should give this kind of disclaimer.
But you referred to certain case laws earlier where you said
yes,
it is the responsibility of the RP to ensure the correctness and accurateness of the
correctness and accuracy is obviously it's on his part, but again he's saying that, see, he has to document each and everything, that why he has included this figure only. So if he can justify that this figure he has relied and it is obtained on this basis, for that part he will be excused. So that is why this disclaimer should be there, and ultimately obviously he cannot shrug off his liability. So again he has to cross check and then put these figures here. So that is why I'm mentioning it
Yeah,
again.
I think I get the point that perhaps it will act as a deterrent for the other party
Deterrent
to
for the other
initiate
party.
the
Yes.
party, but in case it is, then it won't cover the IP.
Yes, sir. So at least, I mean, we can say that we have done our part and we do not fall prey to the, misconduct.
Okay.
We will make sure that we have fulfilled our part, at least. At both the sides, we have to take that up.
Okay.
So, moving further, this document may not be all inclusive and may not contain all of the information. Here, you all are also saying that the recipient may consider material. Every recipient should conduct his own investigation, diligence, and analysis, and should check the accuracy, adequacy, correctness, reliability, and completeness of the assumptions, assessments, statements, and information contained in this document, and obtain independent advice from appropriate sources. The recipient, just like in any other investment option, also like in share market and mutual funds, also you have that disclaimer that don't rely on this. You apply your own mind also. So that is something I think all this is mentioned. The recipient of this IM is under statutory obligation for maintaining confidentiality. Here you are imposing the liability on the other person, responsibility on the other person, that he has to maintain the confidentiality. Within this para, you are saying that of information contained herein, and therefore this document and any extract from it may not be copied, paraphrased, reproduced, or distributed in any manner or form, whether by photocopying electronically, by internet, within other document, or otherwise, without the prior written permission of the RP. Further, any quotation, citation, or attribution of this publication or any extract from it is strictly prohibited without RP's prior written permission. So again, you are making them liable and responsible to keep the confidentiality. And if they are required to do anything, then they have to first seek the permission of the RP. The contents of this report may not be quoted in whole or in part or otherwise referred to in any document without prior permission of the RP. This document has been prepared for general guidance on matters of interest only and does not constitute professional advice. The recipient should not act upon the information contained in this report without obtaining specific professional advice. So that is the complete disclaimer which we can see. Then finally, here is the financial data. Just let's see how is it going. So this is all they are showing. The data is like here from, I think, yeah, from here we can. Profile of the corporate data. About the corporate data and the key selling propositions. So they have mentioned that this company is private unlisted company and it is classified as company limited by shares, incorporated on so and so date. It is classified like that. So this is how you can also mention, and the registered address is also there. Then the authorized share capital, it is also mentioned at the same place. The company was incorporated as the name it is mentioned. So even if the name has been changed from the incorporation, that also can be highlighted here. So the details about the company, how it is working, that is to be or what business it is actually doing, that is something you can mention it here. So it is mentioned that Gilco Exports Limited was incorporated in 1988 and was in the business of steel fabrication till 2005. Thereafter, it entered into the business of manufacturing of airport passenger baggage trolleys. So from the inception, you are telling the history. What was the overall, history of the company, why it started, what business it did, and why it end up with this CIRP process. So that will all be done. So here it is, events leading to the initiation of corporate insolvency resolution process, cause of default. So what is the cause of default? The corporate debtor is a corporate guarantor in respect of loan account of another associate company, namely Gilco Steels Limited, which defaulted in the repayment of the said loan to its creditors. The secured financial creditors therein are UCO Bank and Central Bank of India. On an application filed by the UCO Bank, particularly this branch, before the Honorable NCLT, Chandigarh, The insolvency resolution process was initiated in respect of the corporate debtor by virtue of its standing as a corporate guarantor against the default committed by the Gilco Steels Limited and therefore obligated to make good self-default, which it had failed to do. So normally it is saying that it's not his default, but since it had given guarantee to other company and that company could not pay, therefore the CIRP process is on this company as well. And this is the order number. It is clearly mentioned. And the insolvency professional name is also there. His registration number is also there. Then it is mentioned that in first COC meeting held on 10th November 2023, the members of the Committee of Creditors unanimously resolved to appoint Mr. Rajiv Khurana, interim resolution professional, as the resolution professional in terms of this. Then this is the master data, wherein the complete information can be seen at one glance. So the name of the company, the registered office, then email ID, registered address, then what all, I mean, the authorized capital, paid up capital and everything, the balance sheet date, last date till which the balance sheet is prepared, all that can be seen here. Then the board of directors, their DIN numbers are there. Then their date of appointments are also mentioned. Then next detail is with respect to the index of the charges. And this can be obtained from the MCA portal, as we all understand that. So these are the details obtained with respect to the charges created. And if that has been satisfied also, this is mentioned here. So date of satisfaction is also there. The next, status of the assets of the corporate debtor. So what all assets are there? So there's a land at this particular place, Dera Bassi. Then there is a land measuring 18 Viga. Where is it located? That is also mentioned here. So it is situated at village so and so, and it is in Punjab. So it is all mentioned here. Regarding the current status of the corporate debtor, the corporate debtor is not a going concern and has been out of operation since 2022, as per the information provided by the director on the suspended board of the corporate debtor. Accordingly, there are no personnel deployed at the premises. So that is also something you have mentioned, that employees are not there at the premises. And the last date of income tax return filed for this particular year, the return has been filed lastly. ROC returns are filed up to this date. So regarding the legal compliances also, you are telling here upfront that this is the status. Then in part C, financial details of the corporate debtor are there. So the balance sheet, we have already mentioned here that the balance sheet is available till 31st March 23. But since we know that information memorandum is to be prepared till which date? Till the insolvency commencement date. So they have prepared for the rest of the months. So till October they have prepared. So these are the current figures. The first column which we see, this is the current data which we can see here. So this is what the complete analysis of the assets and liabilities. It has been disclosed. Then finally, the shareholders holding more than 5% of the shares and shares held by the promoters as on this date particularly. So shareholding pattern should also be disclosed. The next is reserves and surplus. So all the schedules which we understand, that is to be prepared here. Next is the current liabilities. So, I mean, whatever the schedules are required that you are doing. Then aging of the for the creditors you are doing. Who all are MSMEs, who are not MSMEs? Are there any disputed dues? Are there any other kind of dues? So I think this requirement is nowadays required as per 3CD also. So that way also you can check, or otherwise as on date position you have to analyze how much is the outstanding, and again you have to classify it MSME wise also, and disputed dues also. That is something to be done. Then next is other current liabilities, then assets. What are the non-current assets? So property, plant and equipments and intangible assets, both the details will be there. So the land detail is already there. Then long-term loans and advances. Deferred tax asset calculation is also there. See, it is the same value because there is no further operation. Then next, with respect to inventory, it is also the same, and it is clearly mentioned as valued and certified by the management. The next is trade receivables. What are the trade receivables? Then again, for the receivables also, this kind of data or the chart has to be prepared for computing the aging of those receivables, whether there are any doubtful receivables or they are considered all good, or there are any disputed also. So that way you have to classify and how long they have been used. So that is what you have to mention it clearly. Then cash and cash equivalents, then short-term loans and advances. So all this financial data you have to mention clearly. Then provisional statement of profit and loss. So balance sheet and P&L both are there. Then in revenue from operation, just like all the financial statements we prepared, we are preparing all this. Just the date was important, that till the date of insolvency commencement, you have to maintain all the data. The next is detail of liabilities of the corporate debtor and the extent to which they are admitted. So here is the detail. Name of the financial creditors, what was the amount claimed, what was the amount finally admitted, and how much is their voting share. So that is what is computed here. If there is any rejection, the reason for that has to be specifically mentioned, that we have already discussed earlier. Regarding the operational creditors also, it is clearly mentioned that this is what was showing as per the books, this is what the claims we actually received, and this is what the claim which we have finally admitted. Next, regarding the government and statutory dues, the same kind of data is to be prepared. Then for the other dues also, then dues towards the related parties. The next is detail of material litigations and investigations initiated against the corporate debtor. That is something which has to be clearly mentioned. And see, the data is mentioned in a table form, like for which year it is pertaining to, what is the name of the official party, if you are aware of that, then in which court that particular case or litigation is going on, name of the counsel which is already appointed maybe, and if there is any date of hearing which is in your knowledge, then you can mention that as well. So these are the things which we have to mention. Then again, there are some notes. The RP is in the process of appointing auditors for conducting forensic audit of the accounts and affairs of the corporate debtor. After the receipt of the report of such audit, and if necessary, the RP shall file appropriate application before the honorable adjudicating authority in respect of the avoidance transaction, if any. So these kind of notes also can be put along with this document. Then the operations of CD are disclosed, are already closed on this. No physical assets except the land detailed herein above are available. So it's a kind of summary which you can say that it will give a special highlight. And then you can mention that we are annexing these documents for the reference purpose. The 3 years documents as it was mentioned, and lastly the name, the IRP. I mean, this is the basic thing, but you can have it as much detailed as you want. So that is something which we can do from our side. So I think the session till now is good to go. Can we switch to EOI then? Expression of interest, Form G.
I think just a couple of things, dear.
Yes,
One
sir.
is this particular IM that you were showing us.
Yes, sir.
There is no redaction, so I mean, this may be a dummy.
Yes, redaction should be there. So I have kept it, noted it somewhere else to tell you all that the redaction has to be there. But this was just a sample, so it can be shown. So.
Okay, so would you be sharing a copy of this IM with us after you have done the redaction part?
I'll do that. It's okay. I'll redact maybe, or see, it's a dummy case, sir. So it's okay.
Okay, so either way, whatever you are comfortable with, but I'll appreciate if you can share this part and the Word file which I showed earlier on the contents
Sure.
of the IM
Yes,
along
sir.
with this presentation.
100%, sir.
Okay, and
100%.
there is one point which I want to point out. In
Hmm.
fact, it's a question which I want to ask my fellow professionals.
Okay.
Obviously the law is very clear. IM is not supposed to be shared with the participants, only with the members, which means the suspended directors cannot ask for it. I'm not sure whether is there any information anybody believes is captured in the IM which the suspended directors are not supposed to know. I mean, the information is all about the corporate data
Right.
and of a
Right.
period which was under them. I
Right.
believe they are the right people to actually vet this document for us. We may miss some important part, we may have written something wrong, and they are the right people to actually highlight that particular thing.
But do you think, sir, they will actually highlight or they will point out the mistakes? It might not happen always, sir.
One may
Yeah.
question or doubt their integrity on this part, and therefore it will be important for us to revalidate whatever points they point out to us. But my understanding is that there is nothing in this information which I can put up which does not relate to them or which they're not supposed to know.
So what I would say here is, it is not for the sake that they already know everything. It is just that they may misuse it, or they may share it with some other people, so that resolution plan, the genuine resolution plan will not come into. So that way it is restricted, that they should not be given. The suspended
But
director should
I
not be
will use
given.
the same argument. See, if they are already aware of the information, they can provide that information to any other person.
Hmm.
By putting up a confidentiality non-disclosure with the RP, at least there is some binding on them that they cannot go out and disclose. Anyway, this does not stop them practically from sharing anything. They can go ahead and share.
Yeah.
If they have the information, they can go ahead and share.
They can, obviously, yes, sir.
Yes, so
But again, sir, the valuation part is not with them. This is something which is done for this
valuation part
purpose
does not
only.
form part of the IM at this stage either. It will come
Yeah,
only after the resolution plan comes on the table.
later on. Yeah. So I mean, if at all that part is there, so that is something not known to them. But rest of it, obviously, they know it all.
Yeah.
But it is not mandatory to share with them. And if they want, undertaking can be taken from them, and then it can be shared. So obviously, we are
This is
here
my
to.
thought that
Hmm.
RPs should take the undertaking, the non-disclosure undertaking,
Yes.
and then share a copy. I won't say you have to need to share in the same format in which we'll putting up. You can give in bits and pieces the information that you have collated and ask them to validate it. And if there's anything significant which is missing, they should point this out to us. If there's something wrong which they find, they can highlight that. So we get a vetting done by the people who are actually in control of the affairs of the company at that point of time.
Yes, but again, I would say that we cannot just rely on them. Obviously, we have to apply our own mind also. But
Absolutely.
yes, that is a good
Absolutely.
suggestion, that it can be shared with them for the vetting purpose. If they are genuinely there to
क्या
help
होगा
out.
पासवर्ड क्या
Yes.
Okay.
But the thing is
Yeah,
that
Okay,
waiting will not
can I
long
request for a couple of minutes break for all of us, and then we start the next part.
For sure, sir, as you wish. I mean, it's your session completely. It's up to you how you want to take it further. So,
Thank you. You're doing great guns, Divya. I'm very impressed by the presentation and the collation of data that you have. Just give us a couple of minutes so that we can all take
sure. So what time we are getting back? 12:30?
12:30 is good. Yes. Thank you
Okay.
so much.
Okay, fine. So we are getting back at 12:30. you all there? Can we start?
Yes, please.
Okay. So, yeah. So before I directly go into the presentation, I would firstly tell something with respect to redactation also. So if there might be some people who are not aware how to redact your documents, because nowadays what we are using is artificial technology. We are using day by day using ChatGPT or any other AI tool. What we are doing is we are directly uploading those documents, and it might happen that the confidential information may leak out. So how to protect that? We must also understand that whenever you are attaching any document to any of these platforms, then you can first redact those documents. So how to do that? I will just share the screen. Just a second.
Hello. OnePlus service actually.
Is my screen visible?
Yes, dear.
Right. I mean, whether the Google homepage is visible, that is what I want to tell you.
No, we are looking at some text here. It's a PDF file.
That is the CIRP guideline. So just wait 1 more minute. I will just reshare. I hope my screen is visible.
Yes.
Okay, so sometimes what we all do, in fact, most of the times what we do is we have to convert our documents from maybe Word to PDF or maybe from Excel to PDF. So we use different tools for that. So maybe you are using small PDF or maybe I love PDF to convert. But there is a proper tool if you use, that is PDF24 org. I'll share this in chat box also, so that you can later on try it for yourself from your side also. So this particular website, this allows you to download this PDF24 tools at your desktop itself. I mean, so that all of your documents will not go to the or will not go to the internet. They can still be there on your they will be still there on your computer itself. You can do whatever you want from there as well. So better to use this kind of technology or this tool PDF24 and start using whatever you want. I mean, you can merge PDF from here, you can split PDF. All the documents will be stored on your desktop only. So there is nothing that the confidential information will leak out to any other platform. So better to use this kind of tool. And what I was telling you about the redactation. So here it is mentioned redact PDF. Can you all see this? Redact PDF. So this is what we are choosing to retain the confidentiality. Redact simply means it will blacken or it will make that portion dark so that others cannot see it. So maybe the PAN number, the GST number, the name of the entity, whatever you want to hide, you can do that. So what you have to do it, you have to just open this redact PDF. You have to choose a file. So suppose I'm choosing one of the files which is there on my desktop, maybe like this particular case law. Suppose I have this file, I'm just using this. This will be opened here on the portal. Then here, suppose I want to highlight Mr. Subodh Kumar Agarwal's name. Then what I have to do is I have to choose the pencil or the brush size, how you want it to be. So suppose I want a horizontal line, I can do it this way. Suppose I want to darken it in, completely black mode. I don't want to show in a zigzag style or somewhat like that. So I will use a proper brush or a proper square kind of thing. So this will be, so this is again, see, this is in whatever mode you are opting, this will be highlighted, and this you can save it further. Even you can have it proper with spray also, like here in spray manner. So whatever manner you want, you can redact it, maybe in diamond form, whatever. So I mean, it is up to you, and you can choose the brush size, how much thin or thick you want it to be. So that way you can clearly choose from this particular site, and you can redact the document. You can then further save it, and then you can use it wherever you want. So whenever you are using any ChatGPT or Perplexity or any other tools where you are attaching the documents, you should first try to uh, redact the document, and then you should try to upload it anywhere. Then moving further to the presentation and to learn what we want to understand for the next topics, the expression of interest and the RFRP. Let us first quickly check the CIRP guidelines for that, and then we will check the few major important points for the practical purpose also. So here is the CIRP guidelines. I hope my screen is visible. Yeah, here it is. Regulation 36A, it provides for the invitation for the expression of interest. So what does it say? What are the legal provisions with respect to that? Let us understand. The sub-regulation 1, it says that the resolution professional shall publish. So again, it is the duty of the resolution professional to publish it, to publish the document with the brief particulars of the invitation for expression of interest in the form of in form G. So this form is here mentioned that you have to mention or you have to give the details in form G. So format for EOI is already specified. So there is no confusion regarding the format, and it is given as an annexure also in schedule 1. We can check that out. What do you mean by form G? Then next, if we talk here, so this form G is important for us, then what is the time limit when it should be submitted? So it is mentioned that at the earliest, not later than 60th day from the insolvency commencement date. So again, timelines are very, very important for all of us. So within this time frame, we have to submit this document form G. Then next is, I'm just underlining this thing, 60th day. And here he has to submit from interested and eligible prospective resolution applicants to submit the resolution plans. Here a clarification is added. The resolution professional, after the approval of the committee, may invite, see it is mentioned, may invite a resolution plan for each real estate project or group of projects of the corporate debtor. This has been recently added. Normally what was happening earlier was, suppose in case of a real estate assignment, there could be some scenarios that for the whole of the project you are not getting a you are not getting one resolution plan, but for separate or the different buildings or for the different premises you are getting the separate resolution plan. So in piecemeal you can have those resolution plans, but earlier then there was no provision to have separate provisions for separate group of projects. So now they have added it here that for separate group of projects, you can have separate or different resolution plans. So nothing in entirety should be there. You can have this in the real estate projects only. So they have clearly mentioned it for the case of real estate projects. Even if you are not getting one resolution plan in entirety, then you can even ask for the separate group of projects. You can break it down in further in different projects, and then you can ask for the separate resolution plans for that. The next is resolution professional. Resolution professional may, with the approval of the committee, invite expression of interest for submission of the resolution plan for the corporate debtor as a whole or for the sale of one or more of the assets of the corporate debtor, or for the both. So here it is important to note that the resolution professional will first show it to the committee, and then he has to take the approval of the committee before inviting this expression of interest. So he has to firstly draft it. Resolution professional has to first draft it and take the approval from the committee, and then he can issue that. Then next is resolution professional shall publish Form G. So because the already we know that the format is given for all of us, we have to abide by that. So Form G is something which we have to take care of. So resolution professional shall publish Form G in one English and one regional newspaper with wide circulation. So it has to be published in English newspaper as well as one regional language newspaper. And the place is very important. The location has to be the registered office or the principal office, if any, of the corporate debtor, and any other location where, in the opinion of the resolution professional, the corporate debtor conducts material business operation. So it might happen that 50 or 60% of the operations are conducted from a particular region. So for that part, for that reason also, you can issue a separate, Form G, or you can have it in their local newspaper also. So it is not, restricted to just publish it in the registered office, but also in a place where majority of the operations are taking place. Then next, it has to be issued or it has to be published on the website of the corporate debtor. Normally, every corporate debtor has a website. Then on the website designated by the board for the purpose, there also they have to do it, and in any other manner as may be decided by the committee. Fine. So next, Form G in the which is mentioned here in Schedule 1 shall state where the detailed invitation of expression of interest can be downloaded or obtained from. So this has to be clearly mentioned therein, that from where they can download the complete details. So that is supposed to be mentioned clearly in that Form G itself, and it has to provide the last date for the submission of expression of interest, which shall not be less than 15 days from the date of the issue of the detailed invitation. So timeline is also very important, and that has to be highlighted in that Form G also. Next, it is mentioned in regulation sub-regulation 4. The detailed invitation referred to in sub-regulation 3 shall specify the criteria for the prospective resolution applicants as approved by the committee in accordance with so-and-so clause of this particular section 25. And it also has to state the ineligibility norms under section 29A to the extent applicable for the prospective resolution applicants. So both the things have to be mentioned very, very clearly. What is the criteria for the prospective resolution applicant and what is the ineligibility criteria? So both ways it has to be mentioned. Next, it has to provide such basic information about the corporate debtor as may be required by a prospective resolution applicant for expression of interest. It should not require any payment of any fees. So that is also must, that you should mention that no fees is required. Then provide details of the corporate debtor's registration status as a micro, small or medium enterprise. This is again, amendment here. We have to understand that if it is an MSME, you have to mention that also. So provide details of the corporate debtor's registration status as a micro, small or medium. So Udyam registration number as well as what is the status that you have to mention clearly. The next, a proviso is mentioned here where provided that where the corporate debtor has any real estate project, the committee for an association or group of allottees in such real estate project representing not less than 10% or 100 creditors out of the total number of creditors in a class, whichever is lower, may relax the following. So in case of real estate projects, because it is very difficult to resolve these cases, some relaxation has been provided. So here we can see that what is the relaxation. The eligibility criteria for submission of expression of interest provided in clause A above can be relaxed, and the conditions regarding the refundable deposit that can also be relaxed. Next, 4A, this is also an amendment kind of. Any modification in the invitation of expression of interest may be made in the manner as the initial invitation for expression of interest was made, provided that such modification shall not be made more than once. So only one time you are allowed to modify. So that is mentioned here. Next, sub regulation 5, it clearly says that a prospective resolution applicant who meet the requirements of the invitation for expression of interest may submit expression of interest within the time specified in the invitation. So who will finally submit? It is mentioned that prospective resolution applicant who meets all the criteria can submit this resolution plan from his side. The expression of interest, expression of interest he will give this time. So expression of interest received after the time specified in the invitation under this clause shall be rejected. So it is clearly mentioned there, anything which is received after the deadline shall not be accepted and it is bound to be rejected. An expression of interest shall be unconditional and shall be accompanied with. So these are the mandatory things which have to be accompanied with the expression of interest. An undertaking by the prospective resolution applicant that it meets the criteria specified by the committee. Then second, the relevant records in evidence of meeting the criteria. So whatever, which all criteria, how you are fulfilling that, you have to mention that. Then an undertaking from his side that he does not suffer any, ineligibility, then relevant information, and all. I mean, I think this is something which we all know, so I'm skipping this. Then moving further for the 8th sub-regulation, the RP shall conduct due diligence based on the material on the record in order to satisfy that the prospective resolution applicant complies with these also. It is not just that the other party has given the information to you. Again, it is the duty of the resolution professional to check it out from his side to validate whether the documents given by him are correct or not. So again, the validation, the vetting part is on the resolution professional. That is his duty to be done, or it is his duty to take care of all this. Then next, the resolution professional may seek clarification or additional information or document from the prospective resolution applicant for conducting due diligence. So this is a right given to the resolution professional. He may seek further clarification or any additional information with respect to checking out whether he meets all the criteria or not. So for the due diligence purpose, he can seek the clarification. The next is the resolution professional shall issue a provisional list of eligible prospective resolution applicants within 10 days. So again, the timeline or the deadline is given for the resolution professionals that he has to give the final list of the eligible prospective resolution applicants within 10 days of the last submission of the expression of interest to the committee and to all the prospective resolution applicants who submitted the expression of interest. So two things are important here. The timeline when he has to finally give this information and to whom he has to give this information to. So to the committee and to the prospective resolution applicants, or to both the parties, he has to give the information. Any kind of objection to the inclusion or exclusion of a prospective resolution applicant in the provisional list referred above shall be made with supporting documents within 5 days from the date of issue with the provisional list. So even the other parties can object to it for if their name is not included in the list or whatever. On considering the objections received under sub-regulation 11, the resolution professional shall issue the final list of prospective resolution applicants within 10 days of the last date of the receipt of the objections to the committee. So this is the overall scenario which we need to understand with respect to the expression of interest. And then let us quickly check this out, the form G, which is there, and how we can prepare it in an efficient manner. That is something which we need to understand. So I am quickly moving to form G. Here it is. I hope it is visible. Form G. Invitation for expression of interest. So the format is already given. You don't have to worry about the format. On the top of it, you have to mention the name of the corporate debtor, operating in which kind of industry, and at what all locations. This is on the top of the form G you have to mention. So invitation for expression of interest, for whom you have to mention the complete details. Then regarding the particulars, name of the corporate debtor along with the PAN and SIN number or the LLP number, you have to mention that. then address of the registered office, URL of the website, details of the place where majority of the fixed assets are located. So see, here this fourth point is important. Details of the place where majority of the fixed assets are located. The next fifth point is installed capacity of the main products or services. So the capacity will tell what could be the turnover of the company and at which capacity it was actually working and till what it can move further to. So expansion or anything that can be checked at this point of time if anyone wants to enter into this project. Then next is quantity and value of main products or services sold in the last financial year. So the valuation part again is very important here with respect to the main products or services which were sold in the last financial year. The number of employees or the workmen, further details including last available financials with schedules of 2 years, list of creditors are available at the URL. So you have to, as we already saw in that regulation, it was mentioned that you have to mention where the details can be obtained from. So you have to mention that link from where the details can be obtained. So URL of that particular site or page where they can obtain the complete details about the corporate debtor. Eligibility for the resolution applicant. Here you have to mention again URL you can mention because there is no detailed space to mention all that. And then lastly it is 10th, 11th, and 12th. 2-3 points are more. Last date for the receipt of expression of interest because date is important to be mentioned here itself. Date of issue of the provisional list. So again, you are mentioning your timelines, then by which date you will finally submit the provisional list. And then last date for the submission of the objections also, you are mentioning it at the same point of time. So this is all. And then again, there are a few more points here. Date of issue of the final list also you have to mention. So 4 dates you have to mention. Then date of issue of information memorandum, evaluation metrics, request for resolution plans, all that you can calculate and you can mention the date which will be there. Then last date for the submission of resolution plans, process email ID to submit expression of interest, and finally the details of the corporate debtor registration status as MSME. So this has been newly inserted. So what is the status that you have to mention here? And then lastly, it is saying who all will sign. So it's only the signature of the resolution professional will be there. His registration number will be there. His address of registered office will be there. And finally, he will be the responsible person for issuing this kind of document. Now I have a sample wherein the details are filled. I will share that as well, so that we all can check it out. It may not be, updated with respect to that MSME clause and all, but still it will hold good for majority of the information. And again, not redacting, it's just for, understanding purpose. It is available on the net also. You can directly check it out. So the name of the corporate debtor. So I'm reading it from the very beginning. Form G, invitation for expression of interest. See, they have not mentioned the name of the corporate debtor, a registered office, etc. at the beginning. You should have it there also. The next name of the corporate debtor, the tabular format we are looking at now. It is the name of the entity, then date of incorporation, then its registered office ROC, which will be applicable here, the SIN number, the address, then next the insolvency commencement date, date of invitation of expression of interest, then the eligibility criteria, it's simply mentioned that please send an email ID to this. But normally we have to specify here the criteria. So I'm not saying that the one which I am showing you is the standard format. I have taken the example from the net only. So we can figure out what all mistakes are there in this particular thing. So we have to, try and avoid such kind of mistakes. and we should present the clear things which are required of us. So these are the dates which you can easily calculate and you can put. Then next, manner of obtaining request for resolution plan. So how this all will be done. So again, they are saying that please send an email to this. Then again, finally, name and registration number of the resolution professional. Since it is an old Form G, it does not have that MSME clause here. But nowadays you have to prepare it with the updated version. So name and the registration number of the resolution professional, Mr. Devarajan Raman is mentioned here. Then address and all, it is there. Then finally, these are the points which he has highlighted. The resolution professional or the committee of creditor should have the discretion to change the criteria for the EOI at any point of time. That kind of disclaimer also they are giving. The resolution professional or the committee of creditors reserve a right to cancel, modify, issue fresh EOI or to extend the timeline without assigning any reason and without any liability whatsoever. Estimated date of closure of CIRP period is this. The aforesaid timeline shall be subject to any kind of extension, if sought, or withdrawal under section 12. That could also be the possibility. So everything is mentioned, and finally the signature and the date and the place is mentioned. So this kind of detail, I think expression of interest won't be a difficult thing to do. So I think now we can check out some of the cases, or let us firstly quickly finish this RFRP part also, and then we can quickly move to some exercises wherein you can judge whether the situation is correct or not, what could be the best outcome in that particular scenario. So I will just share the CIRP guidelines again so that we continue with the RFRP part. Just a second. Rather, I can directly show you the requirements here only from the Word file wherein I have detailed the document or the contents of that particular thing. So I think better is to just check out the contents. So this is something step-by-step flawless resolution process if you really want to go without any errors, how you should start. So this is a step-by-step process. We can take this up first and then we can go for that RFRP thing. Firstly, as soon as you have the assignment, what you should do, you should constitute a team, and in that team you should have various experts like legal experts, finance experts, sector specific expert also, because there might be some industries where where you do not have exposure to, or you do not have the complete knowledge about the industry. So sector expert could also be a person in your team. Then for valuation purpose, you can have one person. For forensic, you can have one person, and then a data room admin. So do not restrict yourself that only you have to do everything. You can appoint various experts for doing different tasks so that your work will be accomplished in much more speedier way and also in within the time frame. So next, here it is mentioned that you can lock your governance. You can make this kind of matrix where there is a maker and there is a checker. So who is preparing what, and then if there is any other person to check that out, and the proper signatures and everything should be documented, because this will form a working paper for you, and it will be a safeguard for you in case any loopholes are later on addressed. The next, email templates. You can frame out what you can design the templates, how the emails will be floated, because there are some common things which can happen in every assignment. So that way you can deliver. Then next is versioning rules, then decision log. So what all decisions you have taken, how you came to those decisions. So step by step, maybe in a brief, you can just mention that this was the main issue, and we have consulted these people, and we have this kind of record with us, and then finally we have reached to this conclusion, something like that. So a decision log is also supposed to be maintained, because why you have taken such a decision, you have to actually justify it. And if you are issuing various versions of document, then you should have a proper log that version 1 was issued on this particular date, and second version was issued on this date, and this is the change between these two versions. The next is create your master register pack. So again, for different assignments, you have to create different master data. What are the claims? What are the litigations involved with that particular entity? What are the contracts involved? What are the assets, licenses, if any, related parties detail, guarantees given or taken, whatever. Then connected persons, who all are the connected persons? You have to prepare a proper chart for that, so that whenever you have the details from the, whenever you have the expression of interest from the prospective resolution applicants, then you can cross check it. Later on, it should not be a burden for you. So from the very beginning itself, you should try and prepare these kind of data. Then regulatory and NOC map also, that whether you have all the, whether the entity has been fulfilling all the regulatory compliances on. Then next is uh, from day 1 to day 15, what you can do is you can take control. Finally, you have to, make this public announcement. You have to take control of the bank accounts, cash controls, inventory locks, then IT and VDR setup. That is something which you have to do. Because see, it's not that normally what we do is let the assignment come to us and then we will plan for it. But let us just have the planning with us from the day 1, that so that as soon as we have the assignment, we are prepared enough to work for it. So just be professional in such a way that we have the checklist, the document, the general documents prepared with us, so that whenever any entity or any assignment is given to us, we are ready with the things. Because every time the law will also be changing, so you have to be updated with that part also. So at least the basic things you can be ready with. Next is the continuity plan. Critical vendors, utilities, payrolls, insurance renewal, all that you need to check. So at least if you have the checklist, you will not miss out anything. Otherwise, what happens is, because of these stringent timelines, you might miss out to check any of these things. The next is kick off the valuation and the information memorandum. You can appoint the valuers. You can prepare the information memorandum skeleton, and you can you can ask for the documents from the corporate debtor. So that time only you will realize whether they are cooperating or not. And next is forensic triage. Again, if you think there is some kind of suspicious transactions are there, or maybe the data is incomplete, or you want to further drill it down, whatever, so you can appoint these forensic auditors also. The next is build a trustworthy information memorandum. So from day 10 to day 30th, you have to focus on this only. So populate mandatory sections like assets, liabilities, security interest, litigation guarantees, and all. Then disclose the hygiene, whether the entity has the proper title for those particular assets which you are uh, having, or whatever is disclosed in the balance sheet, or whether they are encumbered. So that assessment you can have. Then with respect to the off balance sheet items, again, what are those? Then what are the contingencies? What are the litigations pending? You can have a proper chain of those documents. At least firstly, you should have a proper checklist so that you do not miss out. That is what my point is. Next is quality gates. Then again, you have to do some internal reviews, some legal reviews, and you have to tell the COC proper, you have to finally reach to the COC noting that IM versus X substantially, mainly it is complete. Even if it is not, then you have sufficient time within the time frame, you can make it complete. So quality checks can be done during that time period. The next is confidentiality control. Non-disclosure agreement should be prepared in advance, and the proper watermarking and the VDR access tiers should be made, so that unknown person or unauthorized person cannot enter into that. Next is invite the market. So this third part is related to the expression of interest. So here Form G shall be published, and a process note cleared by the COC, because you have taken the approval from the COC, that is to be documented somewhere, that you have properly taken the approval from COC, and then you have published this Form G. Next, what is the objective eligibility? Measurable net worth, AUM, sector capability, licenses, everything is properly disclosed, and you have all the data. So whenever anyone wants to get the details of it, you can clearly show it to them. The next is publish and track. You have to publish the details in the newspapers wherever it is required. We have already seen that it has to be published in newspapers. Even on the websites, it has to be published. And then you have to set a QR window and server clock cutoff also. So the dates are very important, that after this date, you will not allow anyone to provide this expression of interest or anything. The next, provisional provisional to final list, that complete set we already understand that within the timelines you have to pursue all these things. Then next is issue the request for resolution plan. So evaluation metrics has to be designed, and the various weightage on basis of various parameters have to be designed. So firstly, it has to be prepared by the resolution applicant, and then he can discuss it with the COC members also, and therefore finalize it for the ultimate decision making. Next is submission mechanics, formats, encryption, timestamps should be there. Then consortium rules can be there, composition change policy and deadlines, everything. And then question and answer discipline. That means written clarification should be shared to all the prospective resolution applicants simultaneously. So if they are asking anything, then it has to be in writing, and the answers should also be given in writing, because they can also seek clarifications at time. And even we can seek clarification from them whether they are qualified as per section 29A or not, and all that. So that has also to be documented properly. Then finally, we all know this, that we have to evaluate, and then we have to negotiate, and ultimately approval and filings will continue, and then the post approval part. So this is what we need to assess on our part, so that there are no flaws while actually executing the whole thing. So now let us check one more thing, wherein we will see what are the requirements from the point of view of this RFRP. So that is only left out. We can directly move to that. Here we are, the details, the resolution plan, RFRP, and this one also. So we can start from here. I think my screen is visible. For the expression of interest, we have already seen regulation 36A is applicable. Form G has the prescribed format, and section 29A eligibility requirements will prevail here. So what are the mandatory requirements to be put into it? Since they are already reflected in that Form G, I will not go into detail for that. So all this is mentioned here. If you really want to understand what is there in section 29A, I have actually just written that in short. Then financial capability also, net worth statement with CA certification, we can demand from the other party to attach as an, can provide us as an annexure when they are giving the final expression of this interest. So at the time of, issuing this Form G, or when at the time of publishing this Form G, you can put that as a note that we require these documents or the details which you are even attaching. So that way also it can help out, that the financial statements of the company we are attaching, or you can obtain the data from this particular source. So all that you can have both ways. Then technical capability also, then intent to submit resolution plan. So serious intent declaration has to be there. Understanding of the CIRP timeline, willingness to conduct due diligence, and commitment to maintain the confidentiality. So all these four aspects have to be considered by the prospective resolution applicant when they are submitting their this expression of interest. Then these are the supporting documents which you can have along with this. So board resolution in case of companies, consortium agreement if at all it is applicable, authorization letter for the representative, proof of identity and the address, and the professional references, if any, if you demand. So that can be the supporting documents for that purpose. And earnest money also, if it is applicable, then EMD amount and the payment details, refund conditions, what could be there, then bank guarantee details. Next, moving to the request for resolution plans. What is the legal framework, how it moves, and what are the basic requirements? Legal framework is mentioned in Regulation 36B of CIRP regulations. Section 30, subsection 2 also deals with this. And then we have one more, just a second. We have one more section here, 30 subsection 4, which tells you the mandatory requirements, what is to be included in that RFRP. So these are the submission guidelines. First part, last date and time of the plan submission. Just a second. Mode of submission, whether it shall be physical or electronic. What are the format requirements? Number of copies, how many copies are required? Language, whether it should be in English or Hindi, contact details for any kind of queries. Then evaluation criteria shall be there, like feasibility and viability of the plan, implementation timeline, because this is all to be mentioned in the RFRP. We are discussing now what shall be included in the request for resolution plan. So this is all be required from the prospective resolution applicant. So this is what we are discussing. So these are the evaluation criteria. What is the feasibility and the viability of the plan? Implementation timeline, within which what time they will be implementing it, financial analysis and the projections, impact on the stakeholders, management and governance structure, value maximization for the stakeholders, compliance with mandatory requirements. Then finally, this is the resolution plan mandatory component. So we are not going into detail of this. Rather, we are directly taking the best practices which are mentioned. Just a second. So these are the best practices which you can even take up at the time of preparation of all these documents. The first thing is, if there is any format, stick to the format, completely fill the details which is there. So IBBI formats can be taken up as the reference wherever they are available. Then you should also have a version control. If you are maintaining document version control, you have to do that meticulously. I mean, even whenever you are updating anything or you are issuing a further document to it, then you have to have a proper log wherein you mention the original document issue date and all, what is the change in the next one, and what is the issue date of that particular document. The next is legal vetting. So do not again, I'm saying, do not restrict yourself in engaging other experts. Why to keep all the liability on your side? So whenever whatever you are drafting, just get it vetted through some legal person also, and proper document should be finally published for the sake of these things. The next is data room. Proper data room should be there. Who can access, who cannot access, assign a proper person who can control over that and maintain a proper log with respect to that, and obviously have the proper confidentiality undertaking, whosoever is visiting that. The next is pre-bid meeting. Whenever the bidding process has to start, you should try and conduct some pre-bid meetings for the clarification, so that at that point of time there is no confusion. So again, communication gap should not be there. With whomsoever you are interacting, just make the things very, very clear. The next is question and answer logs. It might happen that the stakeholders might ask you something, or it may be the prospective resolution applicant, he might have some queries, or maybe you might have some queries from the other side. So everything should be documented in a very transparent way, so that it can be referred by anyone at any point of time. Then next is issue corrigenda. If you find that there are some kind of errors in the document issued earlier, do not wait for others to tell it to you, but you can directly issue this kind of document wherein you can admit that this was an error in the earlier document and this should be read in this way now. So finally you can do that. Then audit trail, maintain an audit trail of all the communication. Whatever communications you are doing, do not keep that on verbal mode, just document it. It is on for your safeguard purpose. Then wherever required, you need to have COC approval for proper key documentation. So again, you should not leave anything on, don't make yourself responsible for each and every task. Wherever approvals are required, just mention that after approval, I have done this or that thing. So that is very, very important. Now, I think we can take up some case studies wherein you people will check whether the scenario is correct or not. Just a sec, I will open the case study exercises so that whatever we have studied will, finally you will understand the conclusion of it, and maybe you can use this in your assignments also. All right, so here everyone has to be interactive. You can reply in the chat box or you can unmute yourself and then you can answer. So this is a case study where I'm just going directly on the story. Something is missing in the information memorandum. It is not the complete information which is provided there in the information memorandum. So in case of this Falcon Engineering Limited, which was incorporated in 1998, manufacturers hydraulic cylinders for heavy equipment. They are the manufacturers of hydraulic cylinders for heavy equipment. It was admitted into CIRP on 15th March 2024 upon a petition by Canara Bank, and here it is mentioned that the financial debt was 78 crores. The RP, Mr. S, prepared and shared an information memorandum within 25 days of his appointment to expedite the process. The COC constituted on 7th April 2024 noted that the valuation reports were still awaited from the two registered valuers. Now, below is the extract for you all to judge whether this information memorandum holds good or not. This is the extract from the information memorandum, though I have already mentioned it is a faulty one because some details will be missing here, obviously. Company overview. Falcon Engineering Limited, manufacturers of hydraulic cylinders with two plants, Pune and Hosur. Then next, assets. Total book value of the asset is 92 crores. So in short way, they have prepared this whole information memorandum. Liabilities, rupees 85 crores as per the audited balance sheet. The breakup and nothing is there. Receivables, rupees 14 crores, including 5 crores from related entity, Falcon Components LLP. So legal case, so none is significant. So they have mentioned nothing is significant, but what should be the actual take? You should analyze that. Then next is business outlook, strong domestic demand. Valuation reports are awaited. They have mentioned that. Security, regarding security, they have mentioned hypothecation of current assets with the Canara Bank. The IM was circulated without obtaining confidentiality undertakings from the prospective resolution applicants. Later, during the COC discussion, the following facts were surfaced. There was a pending environmental litigation of around 4.5 crore claim. The fair value, which was later determined, was rupees 58.4 crore and liquidation value was 46.9 CR. One property shown as freehold land was actually under leasehold title. So the questions for you are, what are the legal and procedural lapses in this particular IM? Which mandatory disclosure under regulation 36(2) are missing or inaccurate? Can COC decision taken based on this IM stand judicial scrutiny? I mean, whether the decision taken by them will be of any validity or not. What steps should the RP have taken before sharing the information memorandum? Is the case clear? I hope you can easily make out what are the requirements. There are many, many flaws in this. Anyone of you who wants to unmute, and or if you want to give answer in chat box, or you want me to directly give you the answers, you all are hungry and you want to take a break. If that is what you want, we can do that as well, because we don't have much time left. Okay, so this is the possible solution. I'm not saying that this is the exact solution, but here we can see that the relevant provisions are all these regulations and sections involved, and therefore the structure which we have already seen earlier, all that part which is not, completely taken up, that is, which whatever is incomplete, we should try and complete that part and then finally issue the information memorandum. That is advisable. So non-compliances which are identified here are: in the case of valuation, IM is issued before receipt of fair and liquidation values. So the legal provision here says that regulation 35(2) to be exact, it says that IM must include valuation figures. So if you do not have the valuation figures, it's better not to issue the IM. The next confidentiality aspect here, it was compromised. We can clearly see that it was this IM was shared without signing the undertakings. Regarding the disclosures, missing contingent liabilities, litigation, leasehold nature, all that was missing. And again, the disclosure part was incomplete. With respect to financials, there was no recent management account. So the details with respect, the updated details were not there. So therefore, we can say that it is not a good presentation for the IM purpose. So what are the consequences? Any COC decision which is based on this incomplete information memorandum may be challenged before NCLT under section 60 subsection 5. The RP could face disciplinary action for breach of due diligence. And what can be the improvement which can be suggested here? First is circulate IM only after receiving the valuation reports from both registered valuers. Again, you should include the asset register with the proper classification, encumbered or unencumbered, contingent liabilities and litigations, employee dues and CIRP cost summary, then security interest details from CERSI or the ROC. Then next you should ensure all the PRAs sign confidentiality undertakings before IM access, and also attach a summary of fair and liquidation values certified by the valuers. So this is something which we all must take care of. So finally, what is the takeaway for all of you? An incomplete IM is like a half-built bridge. So it leads everyone into risk. So transparency and sequencing are the backbone of the compliant CIRP documentation. So we should take very, very, clear note of it, that everything is
Divya,
to be. Yes, yes, sir.
can you
Yes,
just
sir.
show us the provision which requires valuation part to be included in the IM?
Yes, I'm just moving back to that particular part. For valuation, it is regulation 35(2).
No, I'm not very sure if 35(2) requires IM to include valuation figures.
So I have that guideline
35(2)
also.
35(2) requires that after the receipt of resolution plans, these figures get shared with the others. So after the receipt of resolution plans would mean not at the time of the sharing of IM.
So we can read the exact regulation also. Just give me a moment. I can open the CIRP guidelines. Just a second. Just a minute, let me share that. Now 1 minute, it's not fully visible. It's still loading. Here we are. We have to reach to regulation 35. Hmm. 35A, then 35 it is. Here it is.
Can you just
Yeah,
zoom it on? Yes.
yeah, I'm doing that, sir. Just. Here we are. I'm just increasing the font again.
Yeah, so it says after the receipt of resolution plans,
In accordance with the
the
code.
RP shall provide the fair value.
Yeah, and the valuation reports to every member in the electronic.
This is after the receipt of resolution plan.
The resolution plan. Okay.
So after the receipt of resolution plans would mean not with the IM.
Not with the IM. Yes.
Yeah.
That is something. But again, on a safer side, it is mentioned that. So, what is your take on that, sir? Then, in that case, if valuation reports are not there,
see the reason why the valuation figures have to be kept confidential right up to the receipt of the resolution plan is that nobody should get influenced by these figures and then put up a resolution plan. If the resolution applicants know what the liquidation value and the fair value is, chances are that the plans you will receive would have a plan value closer to the liquidation value or something between liquidation value and resolution plan value, a fair value. And therefore, to get the highest, the regulation requires that these figures be kept confidential, not even be shared with the COC members, right up till the receipt of the resolution plan. So only after the plan are received, we go ahead and share these values with the committee members also.
Right. So, okay, so in this case, I mean, will that amount to misconduct for the resolution professional?
In this case, what you said, there are a lot of other gaps.
Other gaps also. So,
there are a lot of other gaps there.
There is only the gap for the valuation part. If we have not received valuation.
Not with respect to the valuation part. I think with respect to valuation part, obviously is not supposed to disclose at the IM level. Okay.
Fine. Okay, that could be one of the points. Okay, and then we can again cross check it with the requirements, whether it was mandatory for him to, I mean, for all the assets, he should have some kind of he should locate the assets for that reason, maybe that is pointed out that he has not taken all the assets into consideration, or maybe that point can be taken out.
So I think what the regulation says is that it allows the resolution applicants to visit, have a look themselves, assess the value themselves, and then come back and put up whatever they want in the resolution plan, but not be dependent on the valuation carried out by the RP. So that access is obviously provided, and it is for the applicant to figure out what, according to him, is the fair or the value of those assets which he finds. So they must be encouraged to take a visit and look at the assets physically and then put up a plan. And I think going by the documents, you can just say these are the book values. What he has mentioned here, that the book values of the assets are such, and there should be a very clear caveat attached that applicants are encouraged to visit the location, look at the assets, get a fair value themselves, and then put up it in the plan. Because we will not be able to give them any valuation figures for assets or fair value or liquidation value to either the applicants or the committee members before the plans are in our hand.
Can we move to one more case, I think, or you all need a break because it's already 1:30 and your next session is at 1. Is that 2 or 2:30? I'm not sure. What time is the lunch break, ma'am?
How many more case references are there?
Sir, I have 2-3 more to go.
2-3 more?
Yes.
Okay, I think let the concerned officer from the institute decide.
Yeah. Anjali, if you are there,
Yes, ma'am, I'm here only.
what time should we break? What is the break time?
Ma'am, it's 1:30 to 2:30. Next session will start at 2:30.
Lunch break is scheduled at 1:30. So okay, it's already time. We can close our session so that you can have a good lunch and then you can prepare yourself for the next session. So thank you so much everyone for patient hearing, and I'll share my presentation and these checklist also with you so that it will be of some help in your assignments going further.
Thank you
Divya.
very
Thank
much,
you so
ma'am,
much.
for such a nice session. This session was very knowledgeable.
Thank you.
Ma'am, you can share the PPT with me. I will share with the participants.
Thank you everyone. Thank you. I'm
Now,
leaving the meeting.
participants, there is lunch break for 1 hour. Next session will resume at 2:30.
Thank you.
Okay, thank you.
Okay, thank you. Thank you.
Sucheta ma'am, are you here?
Yes, ma'am.
Ma'am, can we start now?
Yes, you start, ma'am.
Okay. Participants, if you are here, then we can start. Please confirm.
Yes, ma'am, please start.
Okay. Good afternoon, all. Now the session will be taken by Sucheta ma'am on the topic drafting resolution plans with case law guidance. Insights from Bhushan Steel Resolution Plan approval. Let me briefly introduce ma'am. Ma'am is CSIP and lawyer. She is associate partner of AAA Insolvency Professionals LLP, IP registered with IBBI. She is associated as consultant with Development Legal Services Law Firm since 2016 till date and in another firm of IT. Ma'am is also having on CSPA reviewed firm named Sucheta Gupta and Associates. Ma'am has worked in the areas of IBC, SASAC, trademark, company law, secretarial audit, listing compliance, legal drafting, FEMA, taxation, finance, account, income tax, etc. Now I request ma'am to take the session.
Thank you. Thank you for the introduction. And thank you to ICSI IPA provide me the opportunity to speak again. And welcome to all the participants for joining the webinar. So, this is the topic basically, the drafting of resolution plan. So I just share the topic first, the PPT first. So I'm just sharing my screen. So my screen is visible.
Yes, ma'am.
Okay, thank you, sir. So basically, this is the topic, drafting of resolution plan with case law guidance, insight from the Bhushan Steel resolution plan approval. So we will discuss all these things in the today's session. So let's start with the session. First of all, we should know what is the resolution plan. So basically, we all are IPs, mostly IPs are attending this webinar. So I think everybody knows. However, I will just explain as per the section. So what is as per the section which is provided as per the IBC? So meaning of the resolution plan as per section 5, subsection 26 of the IBC provides that the resolution plan means a plan provided by resolution applicant for the insolvency resolution of the corporate debtor as a going concern in accordance with part 2. So I think everybody knows who is the resolution applicant. So basically the person, the third person who is who is taking the interest in the company, who want to invest in the company, or want to take over the company as a going concern, they can give their proposal as a resolution plan in the company. So this will be considered as the resolution applicant, and the company which is going for the CIRP process, suppose against whom the CIRP process was initiated by the OC or FC or any of them. So this will be considered as the corporate debtor basically. So here they have mentioned the resolution plan means a plan proposed by the resolution applicant. So who will propose this plan? This will be proposal of a resolution applicant for the insolvency resolution of a corporate debtor as a going concern. So basically this is the process to take the company as a going concern in accordance with part 2, because in part 2 the CIRP process and everything is explained. So they have said this is as per the part 2, and explanation is also here. For the removal of doubt, it is hereby clarified that the resolution plan may include provisions for the restructuring. So what will be included in the resolution plan? This will also include the provision for restructuring. Suppose if a company want to take over the company which is in CIRP, or want to amalgamate this company into in its company. So this the corporate restructuring process is also involved in case of the resolution plan. So the restructuring of the corporate debtor, including by way of merger, amalgamation, demerger. So any type of these forms can also be involved at the time of submission of the resolution plan, like merger, amalgamation, and demerger. So these type of restructuring can also be adopted by the resolution applicant at the time of submission of the resolution plan. So this is cleared by this definition part. Now, we all know, we all have a question in our mind. Suppose a company, if it will go for the CIRP process, so what will be the how can we give a proposal to the company for the investment? If this is a ABC company want to invest in the company which is in the CIRP process, so what will be the proposal? What will be the fair value? How can they offer the price to them? So we will discuss also these points also in this webinar. But first, we will see because you have already taken a first session. So in the first session, already speaker have told you about this in a detailed way, ki what is the IM or what is everything. But I'm just only explaining the steps, which is for the point of view of IRP or RP. So basically, the step for the for inviting the resolution plan, basically, the first step is the preparation of the information memorandum. So the RP prepare the information memorandum under section 29 of the IBC. IM contain financial operational assets or liability details of the CD. And second step is that the issue of expression of interest. So IP will issue the expression of interest with the COC approval. So here with the COC approval, they will issue the EOI and publish the Form G, and Form G will be published in the newspaper or the website of the IBBI, CD, or any other manner, whatever is decided by the COC. Now, EOI specify the eligibility criteria as per section 25(2)(h) of IBC and submission timelines. So when we will submit the EOI, when we will issue the EOI, so there is the criteria. Basically, a criteria will be specified in this key whether individual can take the can invest, can submit the resolution plan or not, and what will be the net worth of the company if the company is submitting the resolution plan. So these type of criteria is also mentioned at the time of the submission of the issue of the expression of interest. Now, the third step for the RP point of view is there, the receipt of expression of interest. So they have issued the expression of interest and Form G published. Now they will receive the expression of interest from the prospective resolution applicant. So basically, who is not the final SRA, matlab successful resolution applicant is not there. Only prospective means there maybe there are 4 or 5 prospective resolution applicant who want to take the who want to invest in the company, who want to submit their resolution plan in the company. So these are the only prospective resolution applicants. They will submit the EOI within the last date, whatever the last date is provided as per the EOI. And PRA submit the supporting documents for eligibility, because you all knows that eligibility is must. The as per section 29A, this is required to be checked by the IP also. So PRA submit the supporting document for eligibility under section 29A of the IBC. RP verify the eligibility and places the provision list before the COC. So whatever the provisional list will come, they will also produce this list before the COC. Now, step 4 is there, issue of final list of PRAs. Suppose they have submit the PRAs list before the COC. Now, COC finalized who is the final PRA. So, issue of final list of PRA, RP prepare and share the provisional list of eligible PRAs with the COC and IBBI, and objections can be raised within 5 days if there is any objection. RP issue the final list of PRA within 10 days of the last day of receipt of the EOI. Now, issue of RFRP, this is the important document. I think you have already attend the session, the first session. So IM, RFRP, everything was discussed in this session, I think so. So this is the issue of request for resolution plan. So RP issue the RFRP to all the PRAs in the final list, and RFRP includes the process document, evaluation metrics, mandatory content of the resolution plan. So everything should be given in the RFRP. Now, step 6 is the submission of the resolution plan. So PRA will prepare and submit the resolution plan in compliance with section 30 subsection 1. So as per if we will say ki the plan should comply these provision of this section also. So we will discuss this section also in detail. Now I'm just telling you what is the step as per the RP point of view. Now step 7, examination by the resolution professional. Now RP will examine. So RP examine each plan as per section 30 subsection 2 for compliance, whether it is complied or not complied, and with the provision of IBC and CIRP regulations and section 29A. So have required to check whether the eligibility criteria was satisfied or not, and non-compliant plan was rejected. Now step 8, the presentation to the COC and complaint resolution plan are presented to the COC. Now COC will approve the resolution plan and 66% voting is required. So you all knows these things. Now after the approval from the COC, the RP will file the application before the adjudicating authority NCLT, and NCLT will give the final approval on this, either reject this, either issue the notice for free invitation, for fresh invitation, or can go the company for the liquidation. So this is on the NCLT ki what decision they will give at the time of the submission of this application before the NCLT. Now, drafting of resolution plan. So these are the steps basically before submission of the resolution plan. Before inviting the resolution plan, these steps required to be fulfilled by the RP, and after this the resolution applicant will submit their plan. So first of all, what we will determine at the time of submission of the resolution plan, what have required to be checked. Suppose we are not the RP as of now. We are a company who want to invest in the CD, or who want to give the plan to the CD. So what is required to be checked on this point of view? Now we will only think what is required to be considered at the time of the submission of the resolution plan. So first we will see whether preliminary assessment. First of all, we will see the preliminary assessment of the CD. So how we will make the preliminary assessment of the CD, corporate debtor? So for this purpose, we have required to collect all the information as per the information memorandum provided by the RP and from the liquidation, the resolution professional, and conduct the financial, legal, and business due diligence of the CD. So how we will do this type of conduct, the due diligence of the CD? So for this purpose, first of all, we should require to check the ROC MCA portal there is the detailed search document is there. So we can download all the search documents from the MCA portal. And if the company is a listed company, so if the company is a listed company, then we will also make the research on the BSE and SC portal, whatever, wherever the company is listed. So some of the information we can download from there. And we can also check the website of the company. If a listed company or if a big company, so there should be some website also of a company. So we should download all the information. We should check the information on the website of the company. So after that, we can also make some research of the assets of the company, because this is very important part ki where the assets is situated, and this is free from all encumbrances, or and what is the status of the assets, machinery, what is the condition of the what type of machinery the company have. So we have required to check detailed balance sheet, because in the balance sheet of the company there is a detailed about the company have been mentioned. So we have required to check the balance sheet of the company. We have required to check the MCA portal. We have required to check the SEBI, the NSE or BSE portal, wherever the company is listed. Or we should also check the memorandum, the information memorandum. This is also a very important document. In this document, the whole information is mentioned basically, and I think they have also submitted the provisional balance sheet of the company, which is not older than one year, I think so. So we have required to check all these information before submission of the resolution plan. So first step is that the preliminary assessment of the company, of the corporate debtor. Now, second step, define the objective of the plan. So if we want to submit as an investor in the company as a plan, so what first of all we should check define the objective of the plan. What will be the objective of our plan? So revival of the corporate debtor, first of all, this should be the objective of ours as a investor if we want to invest in a company. So revival of the corporate debtor as a going concern, and maximization of the asset value. So this should be the objective of our plan if we want to submit a plan in a company. And balance interest of all the stakeholders. We have required to balance all the stakeholders' interest, whether the financial creditors, operational creditors, employee, government, shareholders, whatever is there. So this should be the objective of the plan. Now ensure the statutory compliances. So align with the plan, because as per section 30 subsection 2, there are basically this section is important. So have to require to check whether this provision of this section has been complied or not, and provide the minimum prescribed payment to the OC or the dissenting creditor. Ensure no contravention of law. So this is the insurety of the statutory compliances. Now step 4, structure the resolution plan. So business revival measure. So basically what will be the structure of our resolution plan, whether we want to restructure the company through the merger, through the acquisitions, or through the change of management, or through the new business strategy. So what will be the structure of our resolution plan when we will submit as a investor in a company as a resolution plan, resolution applicant? So what will be the structure of a plan? So these steps are very important, very crucial steps, because we have required to decide first key what will be the preliminary assessment, what will be the objective of the plan, and what is the statutory compliance is complied or not, structure of the resolution plan. Now financial proposal. So what will be the financial proposal of ours as an investor point of view? So the settlement terms of the creditor, debt restructuring, equity infusion. So how we will give the proposal, whether we will give the money through the fresh issue, through the debt restructuring, through the equity infusion of fresh funding sources. So what will be the financial proposal as an investor? Now, operational continuity. So, employee treatment, contracts, supplier, customer. So, what will be the operational continuity when we will submit the resolution plan? So, how we will continue in the company in its operations? So, what will be the treatment with the employee? What will be the treatment with the contract? So, everything should be decided before submission of the resolution plan. Now, uh, uh, we will see ki there are some important provision as per, if we will say as per the IBC. We have already read this section, section 526. This is the important section. This is the resolution plan basically. Now, section 29A, which is basically the person not eligible to be the resolution applicant. So, who is eligible, who is not eligible, is basically provided as per section 29A. Now, section 30, this is the submission of the resolution plan. So I think we should read this section because we have required to comply the statutory provision of this also. So I just show you the window of my screen. My screen is visible now. Just show.
Yes, madam.
Okay, sir. Thank you, sir. Okay, submission of the resolution plan. So we will see this section also. This is basically the submission of resolution plan. The resolution applicant may submit a resolution plan along with an affidavit stating that he is eligible under section 29A. So basically affidavit is required to submit as along with the plan to the resolution professional prepared on the basis of the information memorandum. So as per the basis of the IM, they will prepare the plan. However, they will make some due diligence on some other portals also. Now the RP shall examine each resolution plan received by him in to confirm that each resolution plan now provides for the payment of, because they will confirm what they will confirm as per the each resolution plan as a RP. First, provides for the payment of IRP cost. First of all, CIRP cost have required to be paid in the manner specified by the board in priority to the other debts of the corporate debtor. Now, provides for the payment of debt of operational creditor in such manner as may be specified by the board, which shall not be less than. So OC have required to be paid and which shall not be less than the amount to be paid to such creditor in the event of the liquidation of the corporate debtor under section 53. So whatever the value have required to be given to the OC in the liquidation stage as per section 53 have required to be paid to them. The amount that would have been paid to such creditor if the amount to be distributed under the resolution plan had been distributed in accordance with the order of the priority in subsection 1 of section 53. So the amount that would have been paid to the such creditor if the amount to be distributed under the resolution plan has been distributed in accordance with the in order of the priority of section 53. So this is the waterfall mechanism which is provided ki who will be paid first. Suppose employee employee dues have required to be paid first. So CIRP costs have required to be paid first. So basically, the amount have to be paid as per section 53. So whichever is higher and provides for the payment of the debt of the financial creditor who do not vote in favor of the resolution plan in such manner as may be prescribed by the board, which shall not be less than the amount to be paid to such creditor in accordance with subsection 1 of section 53 in the event of the liquidation of the corporate debtor. So whatever, if there are some dissenting financial creditor, so they have required to be paid first, and this amount should not be less than to be paid to the creditor in accordance with subsection 1 of section 53 in the event of liquidation of the corporate debtor. Now, explanation 1, because we will also see section 53 after this, so the more clarity will came. Now, explanation 1 is also provided, which provide ki for the removal of doubt, it is hereby clarified that the distribution in accordance with the provision of this clause shall be fair and equitable to such creditor. So whatever we will pay, there should be a fair and equitable to such creditors. Now explanation 2 is there ki for the purpose of this clause, it is hereby declared that on and from the date of the commencement of the Insolvency and Bankruptcy Code Amendment Act 2019, the provision of this clause shall also apply to the CIRP of a corporate debtor where a resolution plan has not been approved or rejected by the adjudicating authority, and where the appeal has been preferred under section 61, 62 of such appeal is not time barred under any provision of any law for the time being in force, or where the legal proceeding has been initiated by the court against the decision of the adjudicating authority in respect of the resolution plan. So basically, we have seen above ki align with the plan under section 30 subsection 2. So what is the section 30 subsection 2 is basically ki how we will pay. First we will pay the CIRP cost, then we'll pay to the operational creditor, and now we'll pay as per section 53 waterfall mechanism, whatever as per the provided. So we should comply all this provision of this section. Then we will say ki we have ensured the compliance, statutory compliances. So this is the section, basically the submission of the resolution plan related section. Now section 31 is the approval of the resolution plan. So basically we knows ki fine 66% voting is required for the approval of the resolution plan, and after the COC approval have required to be submitted to the NCLT for its approval. Now section 28, this is the approval of the committee of creditor for certain actions. So this is basically and approval of resolution plan. This is the section. The adjudicating authority is satisfied that the resolution plan is approved by the COC under subsection 4 of section 30, meet the requirement as per this section 30 subsection 2. Basically, it shall by order approve the resolution plan and shall be binding on the corporate debtor, its employee, member, creditor. So this will be binding on all, whether this is the CD, whether this is the employee, members, creditors, whatever, including the central government, state government, or any other local authority to whom the debt in respect of the payment of the dues arising under any law for the time being in force. So this is binding to all or such as authorities to whom the statutory dues are owed. So basically here they have mentioned in a detail ki on whom this is binding, and the guarantors also covered here, and other stakeholders involved in the resolution plan. So provided that the adjudicating authority shall, before passing an order for the approval of the resolution plan under subsection this, satisfied that the resolution plan has the provision for its effective implementation. Where the adjudicating authority is satisfied that the resolution plan does not confirm the requirement as per section subsection 1, this section. So they will by order reject the plan. After the order of the approval under subsection 1, the moratorium order passed by the adjudicating authority shall cease to its effect. So if the resolution plan will approve, then the moratorium will be suspended and moratorium will be ceased. Now, there is the section 28 we have also seen. So this is the section. Basically, this is the approval of the COC in certain actions. So where the COC approval is required, basically this is the section for this. So this is also required. The approval of COC is also required for the approval of the resolution plan also. Now, regulation. These regulation are also very important because you have required to mention in your resolution plan also this regulation. Regulation 38 is a mandatory. You have required to mention on your resolution plan also. So we will see this regulation also because when we will draft a resolution plan, have required to comply these regulation also. So this is the basically I'm just showing you. Because we already read these regulation, but now have to only go through with the regulation, so we can better understand the resolution plan. So at the time of explanation, I can explain you better in a better way. Now, this is the regulation 37. So this is a resolution plan related regulation. So a resolution plan shall provide for the measure as may be necessary for the insolvency resolution of the CD for maximization of the value of its assets, including but not limited to the following. So transfer of all or part of the assets of the corporate debtor to one or more person. So resolution plan can also permit this that transfer of the assets or all or part of the assets of the CD to one or more person. Now, to sale of all or part of the assets, whether subject to any scrutiny, security interest or not. Now, sub-regulation BA, restructuring of the corporate debtor by way of merger, amalgamation or demerger. So resolution plan also permit for the merger, amalgamation and demerger. Now the substantial acquisition of shares of the corporate debtor. So this is also permitted. The substantial acquisition of the shares of the corporate debtor or merger or consolidation of the corporate debtor with one or more person. So the consolidation of the corporate debtor with one or more person is also permitted as per the resolution plan. Now, the cancellation or delisting of any shares of the corporate debtor if applicable. So this is also permitted. Delisting also permitted. Cancellation of shares also permitted. And the satisfaction or modification of any security interest. So this is also permitted. Now, curing or waiving of any breach of the terms of any debt due from the corporate debtor. So this can also be the part of your resolution plan. Reduction in the amount payable to the creditors. So we can reduce the amount because mostly when we will make the payment, the always the reduction is there. Extension of a maturity date or change in interest rate or other terms of the debt due from the corporate debtor. So this is also permitted. Change of interest rate also permitted. Amendment of the constitutional document of the corporate debtor. So basically this is also permitted. Amendment of the constitutional documents like change in the memorandum, change in the articles. So this is also permitted. Now, issuance of the securities of the corporate debtor for cash, property, securities, or in any exchange of claims. So we can issue the securities also of the corporate debtor in exchange for the claim, interest, or other appropriate purposes. Now, change in portfolio of goods and services. This is also permitted, produced or rendered by the corporate debtor. And change in technology, this is also permitted. Change in technology used by the corporate debtor. and obtaining the necessary approval from the central or state government and other authorities. This is also permitted. Now, sale of one or more assets of the corporate debtor to one or more SRA, submitting the resolution plan for such asset and manner of dealing such remaining assets. So these all type of proposals are permitted as per the resolution plan. Now, what is the mandatory content of the resolution plan? Because this is also very important regulation. So what we will add at the time of the giving the resolution plan. So what is the mandatory content of the resolution plan? This is important. Now, first of all, the amount payable under resolution plan. So what is the amount payable as per the resolution plan to the operational creditor shall be paid in priority over the financial creditor. So first of all, we will see कि whether the OC have been paid in priority over the FC or not, and to the financial creditor who have the right to vote under subsection 2 of section 21 and did not vote in favor of the resolution. Basically, these are the dissenting financial creditor shall be paid in priority over the financial creditor who voted in favor of the plan. So whatever the whoever is the dissenting creditors, financial creditor have to be paid prior to the financial creditor who voted in favor of the plan. Now, provided that where the resolution plan provides for the payment in stages, the financial creditors who did not vote in favor of the resolution plan shall be paid at least pro rata or in priority over the financial creditor who voted in favor of the plan. So, pro rata basis have to required to be paid when we will make the payment to the dissenting financial creditors. Now, the resolution plan shall include a statement as to how it has dealt with the interest of all the stakeholders, including financial creditor, OC of the corporate debtor. So there should be include a statement. There should be a statement there. Now, the resolution plan shall include a statement giving details if the resolution applicant or any of its related parties has failed to implement or contributed to the failure of the implementation of any other resolution plan approved by the adjudicating authority at the time in the past. So, if a RA, suppose we are the RA and we are submitting the plan, but earlier we have failed to comply some of the implement the any of the resolution plan which is approved by the AA. So we have required to make its disclosure, its statement, its disclosure also in this resolution plan. The resolution plan shall include a statement giving details if the resolution applicant or any of its related parties has failed to maybe RA or any of its related parties. So they have covered both RA as well as its related parties, has failed to implement or contributed to the failure of implementation of any other resolution plan approved by the adjudicating authority at any time in the past. Now, resolution plan shall provide, shall basically here the shall, so mandatory. So what shall provide? The terms of the plan and its implementation schedule. What will be the terms of the plan and its implementation schedule? Now, the management and control of the business of the corporate debtor during its term and adequate means for supervision of its implementation. So this is also required to be provided as per the resolution plan. Provides for the manner in which the proceeding in respect of the avoidance of transaction, if any, as per section 3, fraudulent or wrongful trading is there, so have required to be prescribed in the resolution plan. And what will be the manner in which the proceed, if any, if it is realized after approval of the resolution plan, so how it will be distributed. So this is also required to be mentioned in the resolution plan. Now, provided that this clause shall not apply to any resolution plan that has been submitted to the adjudicating authority under subsection 6 of section 30 on or before the date of the commencement of the CIRP, second amendment regulation 2022. So basically, provided that this clause shall not apply, where not applied to any resolution plan that has been submitted to the adjudicating authority on or before this second amendment regulation, amendment act. So if any plan is submitted before this date, so in this resolution plan, these clauses are not applicable. A resolution plan shall not provide for the assignment of any avoidance transaction under Chapter 2 of fraudulent or wrongful trading that were not disclosed in the information memorandum. So basically have required to disclose everything in the information memorandum, which is as per the avoidance of transaction or anything. So intimated to all the prospective resolution applicant under sub-regulation 3A of the regulation 35A before the last date of the submission of the resolution plan. Provided that this sub-regulation shall not apply to any resolution plan that has been submitted to the adjudicating authority under subsection 6 of section 30 on or before the date of the commencement of the insolvency and bankruptcy regulation, because this regulation was also amended in 2025. So whatever is submitted to the RA, to the NCLT, or so if any changes is came after this submission, so this will not be applicable to the to this regulation, which is in which the resolution plan was submitted before this date. The resolution plan shall demonstrate that it address the cause of default. It is feasible and viable. It has provides for its effective implementation. It has provision for the approvals required and timeline for the same, and the resolution applicant has the capability to implement the resolution plan. So this is also demonstrated as per the resolution plan. Now, the committee shall consider setting up a monitoring committee for the monitoring and supervision of the implementation of the resolution plan. So some of the changes was came in 2025 after a judgment of the Jet Airways judgment. So supervision or monitoring committee. So these changes came after this date. So the monitoring committee may consist of the resolution professional or any other IP or any other person, including the representative of the committee and representative of the resolution applicants as its member. So who will be consist as per the monitoring committee? It is also made it here clear the RP or any other IP or any other person, including the representative of the committee and representative of the resolution applicant. So there should be the representative of a committee, and because end word is here, so representative of a resolution applicant should also be there as its member. Now, provided that where the resolution professional is proposed to be a part of the monitoring committee, the monthly fee payable to him shall not exceed the monthly fee received by him during the CIRP. So whatever the fee have required to be given to the IP or the RP, this fee should not be more than the fee whatever they are receiving when the company in the CIRP. So the monitoring committee shall submit quarterly report. So here they have also made it mandatory have to submit the quarterly report to the adjudicating authority regarding its implementation. What is the status of the implementation? So in this implementation status have required to submit a quarterly report to the adjudicating authority. So basically this is the mandatory content of the resolution plan. Now I will show you a resolution plan. I have a sample of a resolution plan. So I will just show you. This is the resolution plan. So we have discussed all these regulations. Now we will move on this drafting of a resolution plan, because this is the today's topic is that drafting of resolution plan. So what will be the content of the resolution plan? So chapter wise content should be there. So I will show you a sample also. This is one of the resolution plan because I was involved in the drafting of this resolution plan. Uh, uh, I have uh, I have wiped out the details of the resolution applicant because this is non-disclosure basis. So I just show you what will be the content. So how will be the beginning of the resolution plan? First, resolution plan for which company? For the private limited, whatever ABC private limited. This is the corporate debtor. Now we will mention the SIN number pursuant to the IBC code by the resolution applicant. Who is giving this plan? The resolution applicant. Now, in the matter of, we will also write here in which matter, as per the company have gone for the CIRP process, we will require to mention the matter here also. The resolution professional details have required to be mentioned here. Name of the resolution applicant, constitution of the resolution applicant, address, correspondence of the resolution applicant have required to be mentioned here. PAN number, email ID, phone number, relationship, if any, of the corporate borrower, or date of the submission of the resolution plan. So basically these particular have required to be mentioned here. Now, declaration. We hereby declare that we have read and understand all the terms and conditions relating to the formulation of the resolution plan and hereby express our interest in the submission of the resolution plan for ABC Private Limited, whatever, of the corporate debtor. So there should be a declaration also. We also hereby declare that any confidential or confidential information of the CD that has come to our knowledge or might come to our knowledge, so have required to make this declaration. Now this is the index. So what is the index? Basically the chapter wise. First chapter is the introduction of the resolution applicant. So first we will introduce the resolution applicant. So what will be the introduction? Basically, I will show you this chapter. Chapter 1. So what is introduction of the resolution applicant? So this is the company and doing whatever the business as per the memorandum of association have required to mention here. Now, important details of the company, in which stage this is registered, detail of director, KMPs, detail of companies or firm which is the associate company or subsidiaries, and name of the person who is authorized by the company to submit the resolution plan and their designation, contact number, detail of stakeholders. So we have required to mention all these things when we will submit the resolution plan. Details of the subsidiaries, associate companies, main activities of the products, past performance and the financials of last 3 years, audited financial balance sheet, brief information about the applicant. So we have required to submit all these information at the time of the submission of the resolution plan. Further, it envisages about the proposal with respect to and what is our proposal have required to be mentioned. So this is basically the chapter 1. This is the drafting, the introduction of the resolution applicant have done. Now chapter 2, the information about the corporate debtor. So we have required to also mention the what is the information of the corporate debtor who is in the CIRP. So have required to mention his name, CD, registered office. So whatever these are the information have required to fill here. Now detail about the past performance of the company means CD. What is the CD past performance? Detail of its creditors furnished by the RP. Claim by the financial creditors. So what are the claims which is filed by the financial creditors? Claim by operational creditor. If there is nil, then nil. claim by employee, workman, government. If there is no claim, then nil. Claim by others. So basically, this is the drafting point of view I am telling you, because every professional have their own drafts. Now, details of the listings, litigations by or against the corporate debtor. So what as per the IM, whatever the as per the IM have required to submit. Now, brief information of the corporate debtor as per the IM provided as under. So what is the brief information of the CD? So this is the details basically have required to be mentioned as per chapter 2. Now chapter 3, the project background and the prime reason of the insolvency. So have required to mention also ki what was the reason of the insolvency. So brief details about the project, manufacturing facilities, manpower of employee, estimated reason for the insolvency. So what was the reason of the insolvency have also required to be mentioned here in chapter 3. Now, chapter 4 is the definition part. So, definition and construction. So, what is the definition? Should be there. So we have to mention all the definitions, whatever is necessary as per our point of view, like the business undertaking. What is the meaning of business undertaking? Business permits. So every definition have required to be mentioned, which is important for our resolution plan. CIRP regulation, claim, code, Companies Act. So whatever the definitions part have required to be mentioned here. Now, the construction basically, unless a contrary intention appears, plan 2, the word denoting the singular numbers only shall include the plural numbers and vice versa. So what is the construction basically? Word denoting the one gender only shall include all other genders or not. So what is the construction of the resolution plan? Any agreement or instrument referred in the resolution plans is a reference to the agreement or instrument as amended, novated, supplemented, restated. So have required to mention the constructions basically on which basis the resolution plan is drafted. So have required to mention the constructions also. Now, chapter 5 is the resolution plan, is the resolution applicant has taken into account the interest of all the stakeholders of the corporate debtor to the extent is possible. Summary of brief, the financial restructuring through the compromise or arrangement if they are going to do this. Financial creditor, operational creditor as per the terms. So have to mention the basic, the brief summary of the resolution plan here. And the resolution in my case, in this case, there is a corporate restructuring scheme is there in this resolution plan. So we have mentioned the resolution plan provides for the amalgamation of into which company and how the transfer of the assets will be made. So a scheme of amalgamation have required to be mentioned. So a detailed scheme of amalgamation have required to be mentioned. Now proposal. So this is the important part, ki how we will propose. What will be our proposal for the CD, for the CIRP cost, how much cost have required to be paid here, and what is the priority. First of all, we have required to give the priority of the to the CIRP cost. So I have mentioned here. Now proposal for the financial creditor. So what is the proposal for the financial creditor have required to mention ki how, what is the claim amount and what is the admitted amount and how much we are giving as a proposal. So have required to mention. Now terms of payment, whether we will pay within 1 month, within 2 months, within 3 months, and how we will infuse, whether we will make the allotment of some equity shares or cash component will be there. So have required to mention all these things. Now upfront payment. So how we will make the upfront payment, within which period, within 1 month we will make the 10 lakh and after 15 days will next installment, next tranche. So everything have required to be mentioned in the resolution plan. Claim of the OC, proposal for the employee for the corporate debtor, proposal for the statutory dues if the authority dues is there, proposal for the stakeholders, shareholders. So everything have required to be mentioned in the resolution plan. So this is the moti is the structure of a resolution plan we have seen here. The proposal relating to the terms of the resolution plan and its implementation schedule. So everything have required to be mentioned here in the resolution plan. And if there is a scheme, suppose if you are going for the amalgamation or sorry or merger or demerger, then have required to make a detailed scheme of your merger amalgamation scheme disclosure in the resolution plan. So have required to mention all these things. Now I will show you some of the cases also which is very important to discuss. These are by these case law you can means there are some clarity will come in your mind when you will read the resolution plan or when you will draft a resolution plan. So some more clarity will came. So I think I just suggest ki if you will read day-to-day basis some of the resolution plan in which the resolution plan was approved by the NCLT or NCLT whatever NCLT basically the approved the resolution plan. So if we will read these cases day-to-day basis, we can draft a very good resolution plan. So I will just I will just explain some of the cases in which very recently NCLT have approved the resolution plan. So this is the case in which very recently on 10th September 2025, the resolution plan was approved, and this is the RP, the Kanak Jenny, and in the matter of Profectus Capital Private Limited, this is the financial creditor, and Eagle Electronics India Private Limited, this is the corporate debtor. So basically, in this matter, the resolution plan was approved by the NCLT. So I just show you this content. Sorry, the for. So basically, the resolution plan has been approved by the 82.19% of the voting shares of the members of the COC, and because in this case, the 82% voting by the 82% voting, the creditor have approved this resolution plan. Now, corporate debtor, this is the corporate debtor. Hearing number this was incorporated in 2011, having the registered office address in Maharashtra, Nasik, and having the authorized capital is 4 crore and its paid up is 2 crore 70 lakhs 40,000. Now, CIRP of the corporate debtor was initiated by this tribunal. Sorry. Sorry, on 6 March 2024. So in this date, the CIRP process was started and tribunal appointed Mr. Kanak Jenny as the IP in this case. And subsequently, the first meeting was held on 5th April 2024. And the average fair value of the corporate debtor was determined as 1 minute. So the average fair value of the corporate debtor was determined at 25 lakh 7,000. This is the fair value of the corporate debtor. and the average liquidation value of the corporate debtor was determined 20 lakh. So in this case, it's a fair value of the CIRP at the time of the CIRP of the corporate debtor, and this is the liquidation value 20 lakhs. Now, at the fourth COC meeting, which was held on 12th 6 2024, the evaluation matrix was requested. RFRP was placed before the COC, and this was approved by voting on this date. Now, at 6th COC meeting, in this case, at the 6th COC meeting held on this date, the COC approved the issuance of the fresh Form G. So, Form G was issued and had been received in response to the first round of EOI, because the RP published the fresh Form G on 25th July 2024. So, Form G was published in July. Now, the resolution plan dated this was submitted. So, in this case, who is the resolution applicant? This is the Shubh Lakshmi Investment Advisory Private Limited. So, this is the company who is the resolution applicant, and he has submitted the resolution plan, which was approved by the COC with 82.19% voting on 31st January 2025 24, and consequently this date. Now SRA has deposited, because there is the 5% of the resolution plan NAV value have required to be deposited at the time of submission of EOI. So they have deposited 2,87,500 rupees at the time of the submission of the plan. Now, what is the feature of the resolution plan? Sorry, what was the key feature and summary of the resolution plan submitted by the resolution applicant and as approved by the COC are as under. So, this is a feature of the resolution plan. The SRA is a private limited company which expertise in the providing the financial services, advisory and consultancy services on shares, stock, and to purchase, sale, acquire, hold, dispose of the shares. So they are having this the expertise in this business. And Mr. Anand Prakash and Mr. Hardev are the two shareholders holding 50% shares in the SRA. So this is the brief structure of the resolution applicant who has submitted the plan in this case. Now, how much have been given? So CIRP cost, we will see as per the waterfall. If we will say this is required to be paid first, so 100% have to be paid to the CIRP cost. 31 lakh is the CIRP cost, and this is paid fully. Now, the secured financial creditor admitted amount admitted is this. Sorry. And proposal to pay is only 16 lakh. So this is the proposal. Can I take 5 minutes break?
Yes, ma'am.
Yes, please. Yes, please.
Thank you.
Yes, ma'am, please.
Shall I start now?
Yes, ma'am.
Okay, thank you, sir. So, basically, this was the proposal. In this case, the CIRP cost 31 lakh. This is paid full. The secured financial creditor amount is this, and proposal to pay 16 lakh 31,000. Unsecured financial creditor amount is this, 1 lakh only. Operational creditor, basically the government dues are there, employee and workman dues are there, so 100% have required to be given to the workman and employee as per waterfall section 53. Other operational creditor, they have paid 50,000 points or 76%. And for the contingencies, they have also made 2,50,000 as a proposal. So this is basically the proposed way out in which they have made the payment. So total 57 lakh 50,000 paid in this company, in this CIRP for this company by the resolution applicant. So total amount due is 39 crore 94 lakh 63,000. So this was the total due amount, and against this amount only 57 lakh 50,000 have been proposed and paid by the resolution applicant. Now the tribunal, the adjudicating authority, on this date had sought the clarification from the applicant as to how the financial proposal laid out in the plan meet the provision of section 30 subsection 2A. So they have asked whether your plan have beat out the provision as per section 30 subsection 2A, which we have read in relation to the payment of the CIRP cost in priority of the payment to other debt of the of the corporate debtor. So we can see that they have already paid 31 lakh as a CIRP cost. So they have meet out the criteria which is provided as per section 30 subsection 2A. And as the CIRP cost is stated to be funded over a period of 6 months, whereas the plan contemplates the initial infusion of 7 lakh 50,000, which is for the purpose of settling the claim of other creditors, including PF department, etc. So they have also made the proposal as a OC, because we can say the PF department dues are the claim of the OC basically. And the pursuant to the order dated this, the applicant submitted an additional affidavit dated this, wherein the SRA has affirmed that that we further undertake that the CIRP cost of 31 lakh and any other further amount as may be communicated under the head of the CIRP cost will be paid in full, in priority, upfront, and immediately without any delay. So they have give the affidavit for this also, with the applicable rules, regulations, directions of the Honorable NCLT, and upon the approval of the plan by the NCLT. So this is the proposal which is made by the SRA. Now, what is the source of the funding? So the SRA has submitted that its certified net worth, because they are having the net worth of 22.39 crores with leverages capability to the extent of 40 crores, because they will infuse 50 lakh in 57 lakh basically in this company. So they have given the they have given the declaration that they have the net worth of 22.39 crores and having the capabilities to the extent of rupees 40 crores. The financial resources of the resolution applicant and its proprietor are more than sufficient to provide the funds. So basically they are having the funding, they are having the sufficient fund to meet out the criteria or meet out the implementation of the resolution plan. So they have made this disclosure in this plan. Now, terms of the plan and its implementation schedule. So what is the terms of the plan? Plan terms is 6 months from the date on which the NCLT approves. So this is the term. The plan and it's extendable if required, as the case may be, if any, if delay is not on the part of the SRA. So the plan and it's extendable if required, as the case may be, if delay is not on the part of the SRA. So if there is no delay on the part of the SRA, so this can also be extended. Now, supervision of the plan mechanism regarding the management and control of the affairs of the corporate debtor. So they have also given the disclosure here. Okay, immediately upon the tribunal approved date, the monitoring committee, because we have seen as per regulation 38, a mandatory provision is there for the monitoring committee. So they have said the monitoring committee shall be constituted and the IP insolvency professionals shall convene the meeting of the monitoring committee on receipt of the order of this tribunal. And the monitoring committee shall comprise the insolvency professionals as chairman, one representative on behalf of the RA, and representative to be nominated by the FC. So basically, they have also made this disclosure. The management of the CD will get transferred from the appellant to the monitoring committee. So they have said that the management also transferred. This is the content of the resolution plan. So I am just reading that when you will draft a resolution plan, then there should be these content should be there. So approvals for the implementation of the resolution plan. So as per the resolution plan, the resolution applicant shall obtain all necessary approval within a 1 year, because this is as per the section also provided. He have to take all the necessary approval within 1 year. So required to make its disclosure in the resolution plan itself. Legal cost. So all definite legal expenses incurred in the process of the recovering dues shall be borne by the SRA. In the event of dues are successfully recovered within 3 years, and 30% of the recovered amount shall be distributed to both the secured and unsecured financial creditors in the pari passu. So they have made a clear defining ki how they will distribute if any recovery was there after the approval of the resolution plan. If something is recovered by the SRA after making some expenses, so they will distribute only 30% of the recovery to the secured or unsecured creditor as per the pari passu basis. Now, avoidance of transaction, they have also made a provision in the resolution plan ki how they will treat the avoidance of transaction. So the application for the avoidance of the PUFE transaction has been filed by the RP. Accordingly, the SRA provides that such application will be pursued by the COC after approval of the plan, and all the resolution financial or non-financial benefits of such applications on order of this tribunal shall be available for the benefit of the stakeholders in the proportion of their claim admitted. So, so basically, the benefit of this transaction after approval of the resolution plan will be given to the COC. Non-financial benefit. So they have made it clear all the cost of pursuing such application shall be paid by the COC, because this cost also be beared by the COC only. This not be beared by the SRA. Now, statutory compliances. So they have mentioned here in compliance of this section, we have already read this section in a detailed way. So they have mentioned here the section also. Now they have complied with the regulation 38, because I have already told you have required to mention in the resolution plan also this regulation. So this is mentioned in the resolution plan. Now the compliance certificate. So the IP will submit its compliance certificate along with the resolution plan to the NCLT. So this is the compliance certificate. There is the dates. Every dates have mentioned here. So this is basically the plan. And fair value we have already seen, the liquidation value we have already seen. So against this fair value 25 lakh, the RA provided 57 lakh. We have seen above कि they are giving the total proposal of 57 lakh 50,000. So Now the total realizable amount under the plan is 57,50,000, and fair value they have mentioned here, liquidation value have mentioned here. So the percentage of realization of the amount of fair value is mentioned here, because they have mentioned they have realized 229% of the whatever the fair value is there. So they have realized twice of this value, more than twice. Percentage of the realizable amount to the liquidation value, percentage of the realization amount of the principal amount. So everything is mentioned as per the certificate also and the plan also. So basically I have shown you whatever is mentioned as per the plan and as per the certificate. So this is the case law. One more interesting case law I will also show you. So in this case, the applicant shall supervise the implementation of the resolution plan. Applicant shall forward all the records relating to the conduct of the CIRP to the resolution plan or to the IBBI along with the copy of the order of or for information. So this is the direction was given by the NCLT in this order, and the resolution plan was approved. Now I will show you one more resolution plan case. Very recently in this case, the order was passed for the approval of the resolution plan. This is also a very interesting matter. This is the Piyush Mona is the RP here, and the Punjab National Bank International Limited, this is the FC, and MBL Toll Road Company Limited, this is the corporate debtor. So in this case, the Piyush Mona is the RP for MBL MP Toll Road Company Limited. Now, what is the brief facts of this case? The CD is a registered and classified as a micro, small, and medium enterprise, because we have seen that some specific relaxation was given to the MSME. So the CD is registered with the and classified as a MSME under the provision of the Micro, Small, and Medium Enterprise Development Act. Now, the Punjab National Bank International Limited have filed the petition against the CD as per Section 7 for the admission of the CIRP process. And this was confirmed by the adjudicating authority, and it was admitted for the CIRP process. Now, the RP have collect the claims, everything. So what is the claim of the PNB International Limited? So this is the amount of the claim, 51 lakh. This is the claim of the Punjab National Bank International Limited. This is the amount claimed, and this is the admitted amount. Only 48 lakh or 48 crore was admitted, and 51 crore is the amount claimed. MBL Infrastructure Limited 20 crore, and amount admitted 20 crore, 80 lakh only. 94 is this was the claim amount, but RP admitted only this amount. Income Tax Department this amount, but admitted amount is this. So it has been submitted that the claim submitted by the Income Tax Department is disputed. But this claim was disputed. Whatever is the claim of the Income Tax Department, this is disputed, as the underlying demand had already been challenged before the appellate authority, because in this case, they have already challenged the demand before the appellate authority prior to the CIRP. So this is disputed. Now, accordingly, the COC was constituted on this date with the following composition. So there is only one creditor. So this is only the one creditor. The FC is there only. 100% voting is having with this FC. So this is the basically is the sole financial creditor only in this case. So subsequently, report of the constitution of the COC, why this filed and taken on record by the adjudicating authority, filed this order, dated this. RP has submitted that total 9 meeting was held on this date. So these are the 9 meetings which was held for with the COC. And the registered valuer, these are the registered valuer who was appointed and given the valuation. So summary of the fair value and liquidation value of the corporate debtor is as under. So secured financial assets, including fair value is this, liquidation value is this. Arbitration matter, if there is any realization, so this is the fair value, this is the liquidation value. So basically average value is 9 crore and liquidation value is 6 crore. So this estimate was given by the valuer. Now the appeal has been withdrawn and the same is recorded by the Honorable NCLT in the order dated, because in this case there is there was some suspended management who has filed the appeal against this order, admission order before the NCLT. However, this appeal was withdrawn by them. After some time, they have withdrawn this appeal on this date. So this is also mentioned of this withdrawal order in this order also. So now RP issued the Form G on this date, 4th April 2025. And for submission of the resolution plan on this date, RP issued the provisional list of PRA list have issued. So we have already seen what is the step before inviting the resolution plan. So the RP have complied all these steps. A final list of those 7 PRA, because in this case there are 7 PRA was issued to the COC and uploaded on the website of the CD. So there are the final 7 PRAs are there. So final list of the PRAs is extracted here in Palo. So these are the PRA. In terms of regulation 36B of the CIRP, the RP had issued the request for the resolution plan RFRP IM evaluation matrix to all the eligible applicant in the provisional list. The RFRP was modified in the 4th COC meeting convened on this, and accordingly last date for the submission of the resolution plan was extended. So there is some amendment is made in the RFRP. So accordingly they have extended the date for the submission of the resolution plan, which is extended up to this date, 16th June 2025 only. Now revised RFRP was shared with the PRA on this date, and further the 5th COC meeting was convened and the extension of the last date of submission of resolution plan on the request of the PRA was discussed. And in this process, they have submitted the EMD amount of 50 lakhs on this date. So basically PRA will submit a EMD amount to the RP. So following 3 RP RA, basically in this case there are 3 resolution applicant who has submitted their resolution plan. The MBL Infrastructure Limited, this is the holding company, because the name, if you will see what is the name of this company, this is the company is MBL MP Road Company Limited, Toll Road Company Limited. So basically this is the subsidiary company of this holding company who has submitted its plan in this company. So the company, the MBL Infrastructure Limited, this is the holding company of the CD. So this company also submitted its resolution plan. Now Anirudh Agro Farms Limited, this is also submitted the resolution plan. Shanti GD Ispat and Power Private Limited is also submitted its plan. So there are the 3 companies who has submitted its plan on 16, 10, 23rd June. Now, in the 6th COC meeting convened on this date, the representative of the RA presented their prospective resolution plans. So it was observed by the sole member of the COC that the proposal currently on record neither adequately reflect the enterprise value of the CD nor meet the commercial expectation. Hence, the COC decide to give an opportunity to all the RAs to revise and revise the plan. So the revision opportunity also be given. Now, finally, the GD Ispat and Power Private Limited, after seeking an extension for submission of the revised financial proposal, sought to withdraw because this company want to withdraw from the CIRP and requested to refund the earnest money EMD amount. So the on 7th COC meeting, which was convened on this date, after consideration of the financial proposal for MBL Infrastructure Limited and revise the financial proposal of this company, COC decide to give one more opportunity to RAs to revise their financial proposal. So in this case, one or two times the revision in the financial proposal was made, and the opportunity was given to the RA to revise their financial proposal. So finally, they have received again they have received an email from this company who has already quit earlier, who doesn't want to submit the plan, but now they have received an email from this company requesting to ignore their earlier mail on the withdrawal of the plan and requested the RP to consider the plan as submitted by them in accordance with the RFRP. So they have now made a request that the RP should consider their plan and they will ignore the earlier mail which is related to the withdrawal. Subsequently, it submitted a revised resolution plan via this mail on this date. However, the same was beyond the stipulated time because this mail was sent after a time which was provided for the submission of the plan. So this is beyond the time period. Now, in the 8th COC meeting, which was convened on this date, RP informed the COC that he had received revised financial proposal and addendum from two RAs, namely MBL Infrastructure Limited and Unruth. So they have considered only two proposals, the MBL Infrastructure Limited and Unruth Agro Limited proposal, which was made on 5th July 2025. It has been submitted that both these resolution plans were found to be in compliance with Section 30 because the RP have required to give in their submission to the COC whether the plan was comply or not. So these plan is comply as per Section 30, Regulation 38. Further, since the revision plan of Messrs. Shanti GD Ispat and Power Limited was submitted only after due date, the COC decided to proceed with its original plan submitted on 23rd June 2025, which was found to be non-compliant. Hence, the original resolution plan submitted by this company was not put for the vote. Now COC carried out the detailed deliberation on the feasibility and viability because we have seen this is the mandatory clause as per Regulation 38. What is the feasibility and viability of the resolution plan have required to be submitted by the RAs. So COC made a detailed deliberation on it. Now, after all these deliberation on this date, the voting was conducted and MBL Infrastructure Limited the requisite vote in favor of its plan. So basically the plan of MBL Infrastructure Limited was approved in this case. So the total performance guarantee was also mentioned when we will issue the RFRP. Then some performance guarantee amount have required to be mentioned in the RFRP, but in this case there are something is which is also given to the RP. This is the performance linked initiative. This amount given to the RP, Mr. Piyush Mona, shall be 9,17,000. This amount have required to be given to the RP plus applicable GST, and the same will be disbursed post approval of the resolution plan by the Honorable NCLT and after commencement of the payment to creditor by the resolution applicant. So this because in this case 2-3 times revision was made, so the some more performance linked initiative was given to the resolution professional, which is 9,17,000, and this is required to be disbursed post approval of the resolution plan by the NCLT and after the commencement of the payment to the creditor by the resolution applicant. Now, the applicant has submitted that the value of plan is rupees 9 crore 11 lakh plus CIRP cost as approved by the COC. So this is the proposal which was made by the applicant, and the cash, bank and FDR balance is also in the company, which is on 30th June. If we will see, this is 8 point something crores, something lying in the books of the corporate stood at 10.06 crore. So this was in the books of the corporate debtor. So basically they have infused this amount 9.11 crores as approved as plus CIRP cost, whatever approved by the applicant in this case. So total proposal they have offered, amount offered under the resolution plan is this additional amount for cash and bank balance as per this amount. So the applicant has submitted that as the stated in the addendum and corrigendum, the PNIB upon the receipt of the aforesaid payment in the resolution plan will not pursue any claim. So the claim will be all the claim will be distinguished after this proposal, after this approval of the resolution plan. So made it clear here. Now the value of proposed under the resolution plan submitted by the SRA exceed both the average of the fair value and the average liquidation value of the corporate debtor, thereby making the plan finally viable and commercially justifiable. The SRA has deposited a performance security of 2 crore because a performance security have required to be deposited towards a performance guarantee in 3 tenths. So this is submitted by the SRA. Some most relevant content. So total value of financial proposal, which stand to the tune of 17 crore 49 lakhs. So in this case, total only 17 crore 49 lakh was given by the by the resolution applicant plus CIRP cost. Plus, because in this 17 crore 49 lakh, there is no disclosure ki how much is the CIRP cost. So in this case, 17.49 crore is paid for the to the financial creditor, and plus some CIRP cost have approved by the COC. So the sole financial creditor within 30 days, the SRA undertake that they will pay within 30 days. So the 30 days time is given for the payment. Now, what is the source of the payment? So in this case, they have also mentioned ki what will be the sources of the payment. So 9.11 crore is mentioned as the internal accruals existing cash balance of the resolution applicant. So this will be paid through the internal accruals fund raised by the resolution applicant via contribution by the promoters of the resolution applicant or other stakeholders. So they will pay this 9.11 crores from this. And the resolution applicant is listed on the BSE, NSE, and it has the capability to raise or mobilize the fund. So while another payment of 8.38 crore, because 9.11 crore will be paid as per this amount, and 8.38 crores being paid out of the amount of the CD lying as on this date after making the payment as to the expenses of the CIRP and other payment as clarified by the affidavit. So 8.38 crore have been paid out of the account of the CD. lying as on this date after making the payment as to the expense of the CIRP, and the other claimant being the income tax department and SRA itself is being paid nil, because in this case, if we will see, when we will see who is the claimant. So I will show you again who is the claimant in this case. There are the three claimant, the PNB, the MBL Infrastructure Limited, means the resolution applicant is itself as a claimant here. And it has the total amount which was admitted is 20 crore. They have claimed 20 crore 94 lakh, but admitted 20 crore 80 lakh only. So they are also claimant, and they are also a resolution applicant. So this amount has been settled through their proposal also. So here they have mentioned, which I'm just showing you. So they will infuse total this amount plus CIRP cost, and they will pay within 30 days. And the other claimant being the income tax department and SRA itself is being paid nil amount, as the liquidation value is not sufficient to pay the dues of the sole secured financial creditor, because they are not having the sufficient value, sufficient liquidation value to pay to the secured financial creditor. So they have been paid as a nil. As per the information memorandum, no claim has been filed by the workman and employee in this case, except SRA and income tax department. So there is no other claim. So resolution plan provides that the SRA shall have the exclusive right on all the receivable arbitration proceeding of the CD. So this is also mentioned in the plan ki the SRA shall have the exclusive right on the receivable, whatever is recovered by the arbitration proceeding has to be utilized by the SRA. So they have the exclusive right on all the recoveries arbitration proceeding of the CD. Now, as per the information memorandum, no claim has been filed by the because in this case Madhya Pradesh Road Development Corporation Limited is also there. So there is no claim has been filed with this company. Hence the provision is not required. So no provision was made, or nil amount has to be paid to the income tax department, because already the demand is raised before the appellate tribunal. So nothing has been paid to them. So all these clauses have been mentioned in this resolution plan, how they will pay within 30 days, they will pay 9 crore 11 lakh. So everything is mentioned here in this resolution plan. So if we will read on a day-to-day basis some of the cases which is related to the approval of the claim of the plan, so we can draft a very good plan. Now I will discuss, these are the cases by which I just try to make you more clarity on the drafting of the resolution plan. Now I will discuss the Supreme Court judgment. This is the very recent judgment, you all are aware. So this is the judgment, name is the Kalyani Transco versus Messer Bhushan Power and Steel Limited and others. Because you have already seen the judgment was came on 2nd May 2025. The judgment was came of the Supreme Court, but there are so many arguments on this judgment ki this is not good judgment, because the company was sent by the Supreme Court in the liquidation. So there is a review petition has been filed in this case. So what is the brief of this case? The NCLT passed a order. This is very important case, and this is very interesting also, because NCLT passed the order dated this date to initiate the CIRP against the Bhushan Power and Steel Limited. So this is the company which is the CD, and the CIRP was initiated against this company for the financial creditor. the IRP admitted the claim. How much claim was admitted in this case? There is the 47,204 crore 51,78,073. These are the this is the claim amount. It's a very huge amount of a claim. And on the other end of the operational creditor, the claim, this is the claim of the financial creditor. 47,000 crore is the financial creditor claim, and 21 and the 21 6 crore 600 and 21 crore, this is the OC claim. So basically these are the claim amount in this claim which was admitted. The resolution plan submitted by the SRA. So basically in this case the resolution plan was submitted by the successful resolution applicant JSW. This is a SRA. JSW is the company which is SRA, which had been duly approved by the COC. So basically this plan was approved by the COC, and various applications raising the objection were filed. And because this plan was also approved by the NCLT, however, there are so many applications was raised, objection were filed in the proceedings pending before the NCLT by the erstwhile promoter and the sum of the OCs of the corporate debtor, BPSL. The NCLT wide common judgment and order dated this dismiss the said application and approve the resolution plan of the SRA. So what order is passed by the NCLT? They have wide common judgment ordered on this date, 5th September 2019. Dismiss the said application because various application was filed in this case. So the NCLT have dismissed the application and approved the resolution plan. So basically on 5th September 2019, basically 6 years ago, the NCLT have approved the resolution plan in this case. JSW subject to certain conditions, but there are some conditions have been prescribed by the NCLT for the JSW. So being aggrieved, so because of these conditions which is prescribed by the NCLT, the JSW was aggrieved and they have filed some they have also filed an appeal before the NCLT. So basically, in this case, in 2019, in September 2019, the resolution plan was passed by the NCLT, but there are some condition which was prescribed by the NCLT, and due to these conditions, the GSW, the resolution applicant, have filed an appeal before the NCLT. Now, the meantime, the ED passed the provisional attachment, because in this case there is a provisional attachment order was also passed by the under PMLA. So on dated 10th October 2019, this order was passed because the plan was approved on this date, 5th September 2019, but the order under PMLA attachment was passed on 10th October 2019. So basically, after the approval of the resolution plan by the NCLT, this order was passed and provisionally attached the assets of the CD. So they have give the order for the attachment of the CD assets, BPSL under section 5 of the PMLA. So basically, as per section 5, they have made the order. Now Supreme Court wide common final judgment, because on 2nd May, everybody knows, I think we all are professional, some of the professional who are attending the webinar, who is IP, they knows that on 2nd May 2025, a final judgment was passed by the Supreme Court in this case, and caused and set aside the judgments and order dated this date. So when this judgment was passed on 2nd May, so this judgment have set aside the judgment and order whatever is passed by the NCLT, because they have approved the resolution plan, but Supreme Court dismissed the order, and therefore By this judgment, Supreme Court rejected the resolution plan. So by this judgment on 2nd May 2025 judgment, they have rejected the resolution plan and passed the order for the liquidation. So on 2nd May 2025, the Supreme Court have passed the order for the liquidation of the company. Now, being aggrieved, because they have aggrieved because of this judgment. Who was aggrieved? Basically the COC, basically the applicant, resolution applicant was aggrieved. So being aggrieved, the review petition, in this case, a review petition was filed against the order, because the Supreme Court have passed the order on 2nd May 2025. So a review petition was filed on 29 July 2025. After this date, 2nd May 2025, a review petition was filed on 29 July 2025, and this was allowed on 31st July, held by the Supreme Court. Ki we are of the view that the common impugned judgment and order dated this does not correctly consider the legal position. So this order was made by the Supreme Court ki we are of the common impugned judgment and order dated this, not because this order, they have said that this judgment is not correct and this is not considered the legal position. So they have considered the review petition. They have allowed the review petition by passing this order. Now, while allowing the review petition, because the Supreme Court have allowed the review petition, so all the question of law are kept open. Now, the question of law are kept open, as a result of which this batch of appeal was listed for final hearing on 7th August. So this appeal was listed for final hearing on 7th August 2025. On 11th August 2025, this court, upon the conclusion of argument, reserved the judgment. So basically, when the judgment was reserved in this order, on 11th August 2025, the judgment was reserved, and when the final judgment was passed in this case, this is passed on 26th September 2025. So in this date, the final judgment was came. Very recently, this judgment was came. So I will show you कि first the Supreme Court have passed the order, pass the judgment, and give the direction for the liquidation of the company. But because of this judgment, the review petition was filed by the petitioners, and this was allowed by the Supreme Court, and final judgment was passed by the Supreme Court on 26th September 2025. So what is the brief facts of this judgment? I will show you. The Supreme Court holding, there are so many points. In a very detailed discussion was made in this judgment. So first point for the analysis before the Supreme Court is there कि locus standi, who is the locus standi, means the person having the right to file the appeal or not. So will call the locus standi of the erstwhile promoters. So whether they are locus standi of the erstwhile promoters, whether they have the right or not. So erstwhile, in this case, whether the erstwhile promoter cum directors can file the appeal. So this is the question was arise before the Supreme Court, ki whether the erstwhile promoter cum directors who has filed the appeal before the Supreme Court have the right to file the appeal. It is submitted that the personal insolvency proceeding have been initiated against them, which gives them a clear locus to file the present appeal. So what is submitted? That the personal insolvency proceeding, because in this case some of the personal guarantor, because directors are the personal guarantor in this case, the promoters are the personal guarantors in this case. So it was said कि it is submitted that the personal insolvency proceedings have been initiated against them, which gives them a clear locus to file the present appeal. So this will give the clear locus to them कि they have the right to file the present appeal, because they are the guarantor, or they are the person against whom some of the CIRP proceeding was initiated. So they have the right. Now Supreme Court held. Now what is held by the Supreme Court? This is submitted by them. Ki they have because the some of the personal insolvency proceeding is initiated against them, so they have the right to file the appeal. But what is held by the Supreme Court? So Supreme Court held that heavily relied on the judgment of this court, because in this case Supreme Court relied on a judgment of the Vijay Kumar Jain judgment is there. In view of the aforesaid judgment of this court, since the resolution plan also affect the right of the guarantors, we find that the SRA, JSW and COC are not right in submitting that the appeal at the stance of the appellant would not be maintainable. So basically, because SRA and JSW and COC have filed the appeal against this locus standi ground, so they have said ki this is not maintainable, because they have the right as a guarantor, if they are the guarantor of the case. So and some personal insolvency proceeding are initiated against them, so they have the right to submit the appeal in any case. Rather than non-suiting the appellants on the ground of locus, we propose to decide the appeal on the merit after considering the submission made on behalf of the parties. However, while doing so, the Supreme Court also said that we will consider the conduct of us while promoter during the CIRP. So before deciding the locus standi of the erstwhile promoters, we will also see, Supreme Court said, we will also consider the conduct of the erstwhile promoter, how they are conducting during the CIRP. Are they playing any game? Are they playing any game to delay the proceeding? So we will consider first what is the conduct at the time of the CIRP they are doing. So this question, this was decided by the Supreme Court. This is the first question, first analysis of the Supreme Court. Now second analysis of the Supreme Court is conduct of erstwhile promoter, because they have said we will see what is the conduct of the erstwhile promoter. So now question is arise what is the conduct of erstwhile promoter. So it is submitted by the SRA, successful resolution applicant JSW submitted that erstwhile promoter and director have not attended any COC meeting. Because they are not attending any COC meetings, there is a detailed table mentioned how they are making efforts to cause delay. So because they have also submitted a table in this case in the judgment how they are making the delay. And the Supreme Court held, what is Supreme Court held it can thus clearly be seen, because they have submitted the table also how the erstwhile promoter tried to make the delay of the CIRP process. So on considering this table, it can thus clearly be seen that entire attempt of the appellants has been to spoil the CIRP and to not permit the same to be taken to the logical end, having observed the conduct of the appellant. So this is the observation of the Supreme Court also, they have observed the conduct of the appellant is only to spoil the CIRP, and we shall now proceed to deal with their contention on merit. So this was held by the Supreme Court on the conduct of the erstwhile promoter. Now, third analysis is there. The existence of the COC after the approval of the resolution plan by the adjudicating authority. So what is existence of the COC? What is the existence of the COC after the approval of the resolution plan by the adjudicating authority? So Shri Tushar Mehta sir was there as a senior advocate, Solicitor General, I think, appearing on behalf of the COC, submitting that the COC does not lost its authority after the approval of the resolution plan. So this was submitted by him appearing on behalf of the COC, because this question was also arise existence of the COC after the approval of the resolution plan by adjudicating authority is there or not. because a plan is already approved. So whether the COC exists or not. So this question was also arise. So what is submitted by the Tushar Mehta sir, appearing on behalf of the COC, submitting that the COC does not lose its authority after the approval of the resolution plan. He submitted that the COC remains in existence until the resolution plan is fully implemented or challenged to the approval order passed by the adjudicating authority, attend finality, whichever comes later. So he submitted कि COC remain in existence until until the resolution plan is fully implemented, because only plan is passed, but plan if not implemented, so we can say कि COC still remains in existence till the fully implementation of the plan or the challenge to the approval of the order passed by the adjudicating authority, attend the finality, whichever is comes later. So basically, this was the submission of the Tushar Mehta sir. Now, what is the holding of the Supreme Court? Supreme Court held that we are of the view that the explanation to clause 2 of regulation 18 of the IBBI regulation clarify the position. It empowers the COC to hold the meetings till either the resolution plan is approved under section an order of the liquidation is 33 of the IBC. So this was held by the Supreme Court ki explanation, because regulation 18
Can you unmute yourself? Madam, you're on mute.
Yes, sir. Yes, sir. So this is the third analysis. Am I audible now? Sir, am I audible?
Yes,
Ma'am,
yes.
you are audible.
Okay, thank you. So this is the third analysis which was made by the Supreme Court ki existence of the COC after the approval of the resolution plan by the adjudicating authority. So the Shri Tushar Mehta sir, appearing on behalf of the COC, submitted that the COC does not lose its authority after the approval of the resolution plan. So he submitted that the COC remain in existence until the resolution plan is fully implemented. So, or challenged to the approval order before the adjudicating authority, attend finality, whichever comes later. So this was submitted by the council. Now, what is held by the Supreme Court? Ki we are of the view that the explanation to clause 2 of regulation 18 of the IBBI CIRP regulations clarifies the position. So it empowers the COC to hold the meeting till either the resolution plan is approved, because this is already provided as per the regulation of IBBI. The explanation is also there. We can also see this regulation because regulation is already open on my screen. So I just show you this regulation also. So more clarity will be there. The regulation 18, which was submitted by the Supreme Court. This is the regulation 18. The explanation to clause 2 of regulation 18 of the CIRP regulation clarify the position. Clause 2 explanation For the purpose of this sub-regulation 2, it clarifies that the meeting may be convened under this sub-regulation till the resolution plan is approved and subsection 1 subsection 1 of section 31 or the liquidation order is passed under section 33 and decide the matter which do not affect the resolution plan submitted before the adjudicating authority. So basically this is the regulation 18. This is the meeting of the committee. So the RP shall convene a meeting of this committee before the lapse of the 30 days from the last meeting. And the RP may convene a meeting if he consider it necessary on the request receiving from the members of the committee, and shall convene the meeting of the same is made by the member of the committee representing at least 33% of the voting right. And explanation is there. So this explanation was given by the Supreme Court ki we are of the view that as per explanation, this explanation of clause 2 of regulation 18, it is it empowers the COC to hold the meeting, because in this case specifically mentioned ki the COC can hold the meeting until the liquidation, until the section 31 the order passed or the liquidation order was passed as per section 33. So basically this is referred by the Supreme Court also here ki it empowers the COC to hold the meeting till either the resolution plan is approved under section this or the order for liquidation is passed as per this regulation. So this is basically held by the Supreme Court. Now this is the next ground which is also analyzed by the Supreme Court, the grounds of appeal of distribution. So basically this is the ground of distribution of EBITDA. This because this was also challenged before the NCLT. So this is also a ground of the appeal, the distribution of EBITDA, ki how this will be distributed, whether this will be distributed to the COC or whether this will be distributed to the SRA. So to whom this EBITDA has to be distributed. So is there any applicant who want to give their opinion on this point? If they want to share something on this distribution of EBITDA, what is the logically the distribution of EBITDA, whether this required to be distributed to the COC or whether this is required to be distributed to the SRA. So is there anyone have any view they can share here also? But first, I will only tell you what is the ground which was told by the which was taken by the Supreme Court. This is the distribution ground of EBITDA. It can thus be seen that except the finding of distribution of the EBITDA, present appeal arise out of the concurrent finding by the NCLT. It can thus be seen that the appeal against on order approving the resolution plan would be available before the NCLT only when it is found that the approved resolution plan is in contravention of the provision of the law for the time being in force, or there has been any material irregularity in the exercise of the power of the resolution professional during the CIRP, or that the debt owed to the OCs have not been provided for in the resolution plan in the manner specified by the board. So these are the grounds when we can file the appeal before the NCLT. So these are the grounds basically, whether if we will see ki there is a contravention of any provision of law, then we'll file the appeal before the NCLT for the time being in force, or there is any material irregularity in exercise of the power of the RP during the CIRP process, or that the debt owed to the OCs of the corporate debtor have not been paid, provided for the resolution in the resolution plan. So in these ground, we can file the appeal, or that the insolvency resolution process cost have not been paid. So these are the ground basically in which we can file the appeal before the NCLT. for repayment of the priority of all the other debts or does not comply with any other criteria specified by the board. So these are basically the ground in which we have filed the appeal. So now this is the distribution of EBITDA is the ground in which we can file the appeal before the NCLT. So, what is held by the Supreme Court? A perusal of the material placed on the records in the present matter would reveal that the appeal before the NCLT in this matter does not fit in any of the aforesaid criteria, because these, in this case, the appeal was not filed in as per these criteria. So, having said that, since the appeal before the NCLT itself was not made out, we find that the appeal before this court on the conjoint reading of these section are not tenable, since no question of law pertaining to any of these 5 grounds specified in Section 31 of the IBC arise for the consideration in the present case. So this was also holding of the Supreme Court, because the appeal was not filed any of these grounds of in this case also. So now the other grounds also, which was in which the Supreme Court made the holding, the legality of the clause permitting the COC to extend the period of implementation of the resolution plan. So this is also the analysis point of view. Ki what is the legality of the clause permitting the COC to extend the period of implementation, because COC has extend the period of implementation of the resolution plan in this case. So there is a legality of this clause, ki whether they have any power to permit to extend the period of implementation or not, implementation of the resolution plan or not. So what is the holding of the Supreme Court in this case? Supreme Court holding ki however our experience in the matters like the present case shows that on account of the various exigencies, it may not be possible to implement the resolution plan within the prescribed period. So what was therefore being sought to be done by the aforesaid clauses is to be reserved the certain discretion in the COC to extend the period or implementation of the resolution plan, provided that such an extension if approved by the 66% of the majority. So it was hold ki the COCs have the power, they have the power to extend the period for the implementation also by approving the 60%, 66% of the majority of the lenders forming part of the COC. So we find that such is not the case here. Neither the SRA, JSW nor the COC in the present matter are renegotiating the terms of the resolution plan. So there is no renegotiation was made. Only they want to extend some period. So hence the submission in this regard is liable to be rejected. So whatever is submitted by the applicant have required to be rejected. This was held by the Supreme Court. Ki, however, our experience in the matter, like the present case, shows that on account of the various exigencies, because there are the PMLA proceeding was started, the promoters have filed the appeal against the company, against the resolution professional. So there are the so many various exigencies was there, it may not be possible to implement. So in this case there is not a because this was not possible for the resolution applicant to implement the plan. So because of this only extension was given by the COC. So they have said that this is permitted if there is no renegotiation terms was involved. So there is no renegotiation terms was involved in the extension. So the permission given by the COC for the extension and in the implementation of the resolution plan is permitted. So this was held by the Supreme Court. Now the another analysis ki delay in implementation of the resolution plan. So there is some delay because we knows ki why the why in the earlier decision which was passed on 2nd May 2025, the company was sent for the liquidation by the Supreme Court. Why sent? Because there was a delay in the implementation of the resolution plan. So what is holding after the review petition, what is the holding of the Supreme Court in this case? The delay in implementation of the resolution plan. So the next submission on behalf of the applicants, erstwhile promoter in this regard to the inordinate or delay in the implementation of the resolution plan was the SRA and GSW. So this submission was made by the applicant, erstwhile promoter in this case, there is a delay in the implementation of the resolution plan. On 17th February 2020, wide judgment order, NCLT approved the resolution plan of SRA GSW by modifying, clarifying some of the condition imposed by the NCLT. NCLT inter alia also clarified that the BPSL and its assets were entitled to the protection from the criminal proceeding under this 32A of the IBC, because PMLA was proceeding was initiated. So they have given some protection as per this section. So what is the holding of the Supreme Court? In the fact of the present matter, both the COC and SRA, GSW is the SRA, found it difficult to implement the resolution plan because there was some difficulty involved in implementation of the resolution plan. So on account of various issues, because in this case there are so many issues was going on, PMLA proceeding was initiated against the corporate debtor, BPSL and its management, the provisional attachment of the properties was there. So and the unilateral directions of NCLT to distribute the EBITDA problem is also there. So there are so many difficulties are there. So it is further to be noted that both the COC and the SRA GSW were jointly making efforts before this court for implementation of the resolution plan, which was in fact implemented on 26 March 2021. So basically the Supreme Court's held कि basically they have made all efforts. They have already implemented the resolution plan in 2021. However, there are so many various proceedings was initiated against the CD. So this is only the cause of delay in implementation of the plan. So we cannot say that this is the delay on the part of the SRA. So this was holding of the Supreme Court. Now another analysis also there, the contravention of law. The applicant means the erstwhile promoter have raised a contention that the resolution plan submitted by the SRA GSW was not in compliance with the provision of the IBC. They have submitted this. This is not in compliance with the provision of the IBC and IBBI regulation, as it did not envisage the payment to the OCs before the FC, because they have said कि in this plan the OC payment was not made before the FC, so this is not as per the law. Now the SRA JSW has submitted, this is the submission of the promoters. Now what is submitted by the SRA? The SRA have submitted that the resolution plan was complied with the law as it stood at the time of the submission of the resolution plan, and that any subsequent changes in the law shall not affect the validity of the resolution plan, because they have said, because whatever the changes came only after the submission of the resolution plan. So if any change came after the submission of the resolution plan, so how can they implement this change? So basically this was submitted by the SRA. Now what is the Supreme Court held? The Supreme Court holding is that we are of the considered view that the latest amendment dated 27th November 2019 can have no bearing on the present matter, as the same has been enacted after the approval of the resolution plan by the NCLT, because on 5th of September 2019 the plan was approved, but there is some amendment was made in the IBBI regulation, which was made on 27th November 2019. So basically these change came only after the approval of the resolution plan. So furthermore, it is the tried law that unless an amendment explicitly provide, because the amendment is not provide for the retrospective application, because in this in the amendment this is nowhere mentioned ki this provision is having the retrospective effect. So this was held by the Supreme Court. Unless an amendment explicitly provides for the retrospective application, the same cannot be applied retrospectively. So basically, if you are saying कि this you have required to pay first to the OC and then FC. So this change only came in 2000, in November 2007, 27 November 2019, which was only after the approval of the resolution plan. So this cannot have any retrospective effect. So what I have also make a note here for better understanding कि what change was came after. If we will see 27 November 2019, there is an amendment in regulation 38 was came, which is the mandatory content of the resolution plan. There is a change was came. The change, what is the change? The amount payable under the resolution plan to the operational creditor shall be paid in priority over the financial creditor. So only this change was came after 27th November 2019 ki to the amount payable under the resolution plan to the operational creditor shall be paid in priority over the FC. So this is not applicable on the retrospective effect. This was held by the Supreme Court. Now another analysis, the upfront infusion of the fund by the SRA. So because in this case there is something which was introduced by the SRA, which is in the form of the CCDs, I think. So what is the upfront infusion of fund by SRA GSW? It is submitted by the applicant that the total upfront commitment of 8,550 crores, because they have required to pay this amount, but they have through the equity was made by the SRA, because they have said that they will infuse 8,550 crore as a equity. GSW, as per Schedule 3 of the resolution plan, it is submitted that however only 100 crore out of the said 8,550 crore were infused by the SRA, because the applicant have submitted, they have only submitted 100 crores. They have not submitted 8,550 crore as they have committed at the time of the submission of the resolution plan. They have only submitted the remaining commitment was bought in by way of the CCD, because they have allot the convertible, the compulsory convertible debenture, because what is the nature of this CCDs? This will also be held by the Supreme Court in this case. So it is further submitted that the CCDs are to be treated the same as equity instrument. So this is the submission of the council ki CCD are to be treated as the same equity instrument, and therefore the obligation for the upfront infusion of the fund has been complied. So this was the submission of the council of the SRA COC as per the resolution plan. Now, what is held by the Supreme Court? So, Supreme Court held कि it can thus be seen that this court has reaffirmed its view that a CCD is to be compulsory maturity without, it has been held that it must be treated the same as equity instrument. So what is held by the Supreme Court ki the whatever, if they have infused some money through the CCDs, so this CCDs will also considered as the equity instrument. So they held ki that it must be treated as the same as the equity instrument. So we are therefore of the view that the CCDs infused by the SRA GSW are to be treated as the same as an equity infusion. So in light of this factor, the commitment of the upfront infusion of equity has been duly complied with by the SRA and JSW. So have to consider when you will draft a resolution plan, if you will give anything through the CCDs will also considered as the equity instrument as per this Supreme Court judgment. So this is very important and crucial part. Now distribution of EBITDA, because this when we will see the Supreme Court judgment which was passed on 2nd May 2025, in this there is a because they have not made any decision on the distribution of the EBITDA, but in this case after the review petition, the Supreme Court made some holding on the distribution of EBITDA also. So the Supreme Court hold कि we are of the considered view that unless there is a specific provision with regard to the distribution of the EBITDA in the RFRP permitting, because unless there is a specific provision, because in RFRP there is no such provision for the distribution of EBITDA. So we are of the considered view that unless there is a specific provision with regard to the distribution of the EBITDA in RFRP permitting the COC to raise a new stand at this stage will be totally inconsistent with the avoid object for which the IBC was incorporated. So because COC now only raised this issue was not raised earlier, and this was also not mentioned in the RFRP. So why this new issue was arise here? So when a resolution plan is approved, so this was the holding of the Supreme Court, कि when a resolution plan is approved, the SRA takes over the management of the corporate debtor with the possibility of turning a loss-making concern into a profit-making, because all efforts was made by the SRA to turn the company to the CD from the loss-making to the profit-making. So all the risk is with the CD, so running to the further losses. So these decisions fall under the umbrella of the commercial wisdom of the COC. So once a resolution plan has been approved by the COC and the adjudicating authority under this section, permitting any claims to be reopened which were not the part of the RFRP or resolution plan, because this was not earlier the part of the RFRP and resolution plan. So in our view, will be doing violence of the provision of the IBC. So in that view of the matter, the argument of the COC as well as the original promoters in this regard are liable to be rejected. So basically, this was held by the Supreme Court because earlier they have not mentioned any provision for the distribution of the EBITDA. Now the another analysis of the Supreme Court, the contingent claim of the jaldi, because this was a contingent claim was also filed by operational creditor. The name is Jaldi. So we now examine the contention raised by the appellant Jaldi. It is submitted that the appellant was the larger OC of the corporate debtor. So BPSL and has been wrongly classified as the contingent creditor, because they have submitted the credit they have wrongly classified as a contingent creditor. They are already operational creditor of the corporate debtor. So what was the holding of the Supreme Court in this case? It can thus be seen that the foreign award, because in the Jaldi claim is related to the foreign arbitration award. This is a claim related to the foreign arbitration award related claim, will be deemed to be the decree of the court only when the court is satisfied that the foreign award is enforceable under Part 2, Chapter 1 of the Arbitration Act. So there is no certainty whether the foreign award will be enforceable if court satisfied as per the Arbitration Act. So therefore a foreign award would not be automatically enforceable in India, because this is the law as per the arbitration, the foreign award would not be automatically enforceable in India. This is only as per the discretion or the decree of the court only. So we are therefore of the opinion that in the present matter, as well as the COC exercised its commercial wisdom while approving the resolution plan, whereby the applicant Jaldi was classified as a contingent creditor, and such a decision is deemed to be the non-justifiable by this court in view of the case Shashidhar. This reference also was given by the Supreme Court. So the NCLT and NCLT have also approved the resolution plan, and in light of the settled principle of law, we find no question of law being arised by the applicant Jaldi, and therefore the appeal filed by him is liable to be dismissed. So he will be considered as a contingent creditor, not as the OC, because the foreign award is not automatically enforceable in India. So basically, this was held by the Supreme Court. Now another analysis which was made by the Supreme Court, the pre-CIRP dues of the Medhi and Darsal, because these are also a operational creditor. They are claiming that they are the operational creditor. So it was submitted by the appellants that they were promised their payment of pre-CIRP, because their payment is related to the pre-CIRP dues by the RP as an incentive for continuing to do the business of the corporate debtor during the CIRP period in order to keep it as a going concern. So they are saying that they are the OC also. So what is the holding of the Supreme Court? We further find that there is nothing on record that shows that the COC had approved such pre-CIRP payment and such payments to the applicant. Find no mention anywhere in the resolution plan, because this was not mentioned in the resolution plan also. So we further find that there is nothing on record to show that the COC had approved such pre-CIRP payment, because this pre-CIRP payment never approved by the COC and not the part of the resolution plan. So the pre-CIRP payment and such payment to the applicant find no mention anywhere in the resolution plan. So this will not be considered as the OC. So this was held by the Supreme Court. Now, this is the final conclusion of the Supreme Court. We therefore do not find any merit in the contention of either the ex-promoter cum director of the corporate debtor or the COC in that regard. So if such a contention is accepted, it will frustrate the very purpose for which the IBC came to be enacted. So this was held basically by the Supreme Court. In that view of the matter, we do not find any merit in this appeal, and the appeal are therefore dismissed, and impugned judgment dated 17th February, which was passed by the NCLT for the approval of the resolution plan, was upheld. So this judgment was passed by the Supreme Court in this recent case. So basically, this will highly impact on the approval of the resolution plan, because we have seen so many things in this judgment, that the CCDs will also considered as a equity. We will see the foreign, if there is any foreign award is there, so this will be considered as a contingent due only, not the OC. So this is very learning, or very powerful judgment, can say, which can impact on the resolution plan. When we will draft any resolution plan, we should also consider this judgment. What is the finding of the Supreme Court in this? So I'm just asking whether the EBITDA, if we will say, because in this case, this is written by the Supreme Court, there is nowhere is mentioned in the RFRP and the resolution plan for the distribution of the EBITDA. So this will not impact, this will not be discussed at this point of time. So I just ask the participants if they have any idea if there is some EBITDA in a company which is in the which is a corporate debtor and taken by the SRA. So how the distribution of this EBITDA has to be made? If anybody want to share their view, they can share, or they have any idea is some other judgments in which the EBITDA was distributed among the financial creditor or the SRA, so they can share their views. Or if they have any question, any query, they can also ask the questions. So, have any idea ki what will be the distribution of the EBITDA?
I feel
Yes, sir.
it has to happen in accordance with the resolution plan approved. And if the resolution plan is silent on this subject,
Yes, sir.
then the right of the EBITDA cash flows is with the resolution applicant and not with the creditors. The creditors get what is there in the resolution plan.
Mhm.
The resolution plan does not mention anything on EBITDA.
Sub-
They only
yes.
get so.
So in the resolution plan, can they mention that the distribution to the EBITDA has to be distributed to the COC? So is this logical? The
I
distribution
think
of
yes, there can be a mention that the company or the resolution plan assumes a cash-free position. So any cash surplus that is there on the transfer date would be given to either the secured creditors or some other component, and that must be mentioned in the resolution plan. And I think this will not be mentioned
Yes,
the
because in this
RP,
case, this was not mentioned in
unless
RF.
the
Yeah.
RP in the RFRP itself
Yeah.
points this out. That you
Yes.
have to categorically point out what would you be doing with the cash surplus.
Yes. Yes.
Unless that is
So-
mentioned, I don't think so. Resolution applicant by itself will come up and give this money to the creditors.
So basically, in this case, the Supreme Court have said ki you have also not mentioned in the RFRP how the distribution will be made. So how can you will take the ground of at this moment? So is there any other query or any other question have to be discussed? We can take the discussion. We can discuss if anybody want to discuss something.
The one point which I can
Yes, sir.
request my fellow
Yes, sir.
professionals to share their
Yes.
view is on the projections that needs to be undertaken. See, what we have discussed now is what is required from a regulation point of view to be included in the resolution plan. But
Yes, sir.
the crux of the resolution plan is the commercial.
Yes,
And
sir.
it would require some kind of number crunching, some
Yes.
projections, the
Yes, sir.
assumptions for those projections.
Yes, more projections are there. When we will submit the resolution plan, I think 5 years projections have required to be submitted along with the plan also.
But are we required to
Yeah.
then convert those projections into a DCF method valuation and say, okay, this is why we are looking at these numbers, and therefore we are suggesting such kind of a resolution plan value? I mean, one part is having 5 years of projections. Now, the 5 years of projections give you a net present value of say 100 crores.
Yes.
Then would you go ahead and put a resolution plan worth 100 crores, 80 crores? Is there any linkage between the two, or the projections are just a standalone activity to be incorporated or attached to the
Yes, this is
resolution
only
plan?
based on the activity have to be how they will going on in the future, na, sir? Basically, the projections, they have prescribed they have given the projections, but how they will deal after the passing of the resolution plan? What is the implementation? How they will implement the resolution plan?
One important question
Yeah.
that comes up is that if during that resolution plan period, the projections are not met,
Yes.
would it then be regarded as a failure in the implementation of the resolution plan?
This is also the question of law, sir, as per my understanding. Maybe is there any case, if anybody have any idea they can share? If the projection was not meet out in the plan, whatever is submitted as per the plan, and this is not meet out, so whether we can assume ki this is not the implementation of law or not, implementation of plan or not, sorry. So, sir, what's your view, sir? Have to share?
If it is very much a part of the plan, that any deviation from what is there written in the plan would constitute a breach of the plan. But I believe the practical solution would be to go back to NCLT, point out the implication of this breach. Otherwise, it can land up in liquidation. And I think NCLT will probably accept those deviations and give some leeway to the resolution applicant to implement, assuming that the other creditors do not have any objection to this deviation.
But sir, I think the projection is in itself. If we will say this is the projected, this is not sure. NCLT can say, suppose if we have filed the application or petition against the non-implementation of resolution plan because of these projections. So the we can say ki the projections is not the reality basically, na sir. This is not the real factors, real numbers are there. These are only projection because in itself this is saying ki this is the projection only.
Correct. Projections obviously have,
Yeah.
by definition, an element of uncertainty.
Yes.
So there
So
would be deviations from what is projected. As long
yeah.
as the deviation is not substantially hurting the implementation of the plan, it should not affect. And I think the monitoring committee can take into its stride and move along. Otherwise, the RPO, whoever is the chairperson of that committee, would probably have to highlight this deviation to the tribunal.
Yes, sir. So, thank you so much for sharing your views, sir. Or any other participants, if they want to share something or they want to discuss something, they can share or discuss. Otherwise, I will mm, conclude the session. So, I'm requesting to the ICSI IPA, can we conclude now? ICSI IPA is there? I'm requesting to the ICSI IPA, please conclude the session now. If there is anyone from the ICSI IPA.
Sucheta ma'am, are you here?
Yes, I'm here. I'm asking, can we conclude now, ma'am?
Sure, ma'am. We can conclude if there are no questions.
No questions are there, and we
Okay.
have already made the discussion.
Okay. Thank you very much, ma'am, for such a
Thank
nice
you.
session. The session
Thank
was
you.
very interactive also. Ma'am, please share the PPT with me.
Yes, ma'am. Yes, ma'am.
Thank you.
Thank